Call the list.
My lord,
May I be permitted?
my lord, may I be permitted to mention, my lord, the on determination of Honorable Justice Ajay Kumar Mukherjee, my lord. My lord, this is a CRR, my lord.
The urgency.
My lord, the urgency is this, my lord. I am praying, my lord. I am praying for the quashing of the, my lord, charge sheet, my lord, pending since 2022, my lord. My lord, in the meantime, I'll give the notice to the other side, my lord. May this matter be taken. This, my lord, in this matter,
I cannot take up hearing matters.
my lord,
I am already busy with the matters. No.
my lord, in this matter,
If there
senior
urgency,
advocate
No.
is,
No,
my lord,
no,
kindly, my
no
lord,
hearing.
anytime, my lord.
No, within
But-
15 days, I cannot conclude. My determination is full. I cannot give you a time. Yes.
My-
Matter came up before your lordship in application, but substitution allowed by your directed to come under any hearing thereafter. 1993 years before into
Appeal for the year.
1998. And another application for substitution beyond that.
May I be permitted to seek leave to file one CAN application, lordship? The urgency is that, lordship, we have filed one REIT application, lordship, challenging one vacancy notification, and your lordship was pleased to direct to stay the operation of the vacancy notification, not to come to the conclusion as the matter, several matter pending. Now, lordship, despite of that order, lordship, now that respondent authority have done that, further issued a fresh notification in a different number, lordship, in the same area, lordship. I am seeking indulgence
Then
of your lordship.
it's a new cause of action.
Lordship, as I
You
have,
file one new REIT. Why the application can?
lordship, that is as the respondents are the same, lordship, and they have issued a fresh notification despite of the notice.
Respondent all over Bengal respondents the same.
No, lordship, that in my case, lordship, that that
I
despite.
understand new notification has been published. So you file a REIT. Why
But
the
let-
can? How
let-
can I?
let
How
this-
can I?
Let the state come with a report, lordship, that where the high, despite of the notification, how
When
they
the
can come.
notification is there,
Yes, your lordship.
then you file a paper a REIT, express REIT.
Lordship,
Okay.
as your lordship.
Why can I cannot dispose of the your grievance cannot be settled.
Lordship, I will file.
Okay.
Lordship, may I mention?
Seventh of
My lord,
March.
in this matter, my lord, I am appearing for the complaint opposite party, my lord. My lord, only difficulty is, my lord, we are not opposing the mentioning, my lord. Only difficulty tomorrow, we will not be available, my lord, because we have some personal difficulty tomorrow. If your lordship
Tomorrow is not there. Day after tomorrow.
so kindly give a day after tomorrow, we have no problem.
Sixth. Sixth. It would be just.
And one more thing, my lord, may I point out?
SD. 6. Twelve 30.
My lord, 6th, 12:30.
12:30.
If the lordship, may I mention matter?
Just right. 12:30. Time code. ठीक है.
If
On mentioning this matter, the matter appearing under the list of Honorable Justice. Two
matters, my lord.
Okay, these matters appearing under in the list of Justice Ajay Kumar Mukherjee be listed for hearing on 6th of March 2025 at 12:30. Filed in here. Yes.
May I permit to mention one read application leave to move before 7th March, your lordships. Lordships, in this matter, your lordships, as license of FPS dealership is going to be issued on 7th March, your lordship. Private respondent, several criminal.
Take the mic.
Private respondent, several criminal antecedent, your lordships. Petitioners application stand down due process of law, your lordships.
Turn down
Due process of law, your lordships.
without following due process of law.
Yes, your lordships.
So you have preferred on writ petition.
Yes, your lordship.
Today is the 4th.
Yes, your lordships.
It will appear tomorrow or 6th. It will appear 6th
Your lordships,
automatically.
may I be granted to leave, your lordships,
For what leave?
leave to file a
File
application, your lordships.
application.
Read application, your lordships.
File of, okay.
Leave to file করতে পারবো না তো।
Why leave? Why leave is required?
So without leave, in file is not come before
What is
7th
the
March, your
file?
lordships. No.
It's required to file and move it by tomorrow.
Yes, yes, your lordships.
Tomorrow.
Yes, your lordships. Tomorrow, your
That's why I'm asking you when you want to move 6th, it will appear automatically.
so number is
It will automatically appear on 6th.
7th March, your lordships.
So 6th is if the 6th order
Okay,
is
Lordship.
passed, then
Because 7th March, your lordships, license will be issued
6th
to
is
your
the before 7th March.
Yes, your lordships.
What is the purpose of leave?
If your lordships
If you
granting,
file today, it will appear on 6th.
no, your lordships. This is not possible, your lordships.
নাম্বারটা পাবেন
Number is not coming, your lordships.
Leave grant.
There is a number.
It is not appearing on within 48 hours.
48 hours required to, I have to serve notice for 48 hours.
Yes.
But to get the number, it will take another 1 day after filing. This is the system is going on. 1 day to get the.
So within 48 hours, you did not get the number.
I will get the number within 20, after 24 hours. Thereafter, I can serve the respondent. Then I have to give the 48 hours notice. The 72 hours. That's why leave is required to file and move it.
টেম্পোরারি নাম্বার
Within 48 hours.
Yes, your lordships.
Okay. Tomorrow, leave granted. Yes.
May I mentioning 3 matter regarding extension of interim order of that matter is clearer regarding the Mukherjee result.
Lordship, may I permitted to mention, Lordship, it is an recording for abatement in connection with second appeal, Lordship.
Abatement in connection with second appeal.
Yes, Lordship.
Recording of abatement. What is the purpose of recording of already abated?
Lordship, appeal in the year 97 during the pendency, Lordship.
The respondent.
Yes, Lordship. I am the
What is already abated?
no, Lordship. The appellant expired, but no application for substitution has yet
I
been.
understand no substitution application is there, nothing is there. Appeal has already been abated. So what is requirement for recording abatement? You want disposal,
Yes, Lordship.
then you have to serve upon the appellant
I served the advocate of the appellant. And
whether they have all received, all the advocates.
they received and they they send us NOC, no objection.
No. Have you served upon the all learned advocate for the appellant?
Yes, Lordship.
Then appellant has already expired. What is the purpose?
But no substitution has been made.
Whatever may be, if I take the application, I have to direct you to again serve upon the appellants directly or their legal heirs
Obliged, Lordship.
under the heading application. Yes,
Sir, may I point to item number 58, my lord,
today's list.
today's list. My
What do you want?
last 2 occasions, your lordship was pleased to allow me time, my lord. But till now, the appeal has not been taken up, my lord. The appeal is running as item number 16 before the lordship of the lordship Honorable Justice Rajasekhar Mantha, my lord. My lord, I am praying for 2 weeks adjournment, my lord.
Item number 58.
58.
You are for the
I am for the writ petitioner, my lord.
writ petition. You
Challenging the
preferred an
order of
appeal.
addition of party, my lord. The appeal has been filed.
Appeal preferred against the order of addition of parties.
Yes, my lord.
You want adjournment.
2 weeks, my lord.
Item number 58.
58.
58.
58.
Yes. Next. Yes,
But at not 50.
My lord, it is adjourned, my lord.
I will call this matter. Let me take up the matter. You have mentioned it. That's all. I will give you the
53 and 54 of
Time.
today's list.
53, 54.
If not been taken up today, Marat, it's a regard to vacancy matter, Marat. That's why I'm bringing, let the matter appear tomorrow, if not taken.
Not today, then tomorrow.
Tomorrow to be mentioned.
Call the matters.
I'll be very, in the item number 11 for the petitioners and respondent in item number 10. If your lordship allow me to place my case in item number 11, I can proceed. I have
Item number 9, 10, 11, three matters.
served the response. Matter is because my matter is motion. I have served the respondents and I have
For the state.
and
You are for the state.
Yes, my lord. Represented.
So you are the petitioner of item number 11.
11.
11. Abdur Rauf. And it was argued on the earlier occasion that the matters are identical in nature.
No more identical. This is in respect of
Compassionate
claim
appointment
is
of
not
MR dealer.
claim is not identical. Facts are identical. I am likely to be argued in proper manner. My case is that I am the only entitled person. He is claiming, Abdul Wahab claiming, he is the only entitled person.
All the persons, also all the three petitioners claiming they are the
Because the entitlement.
entitled persons. only.
Entitlement. Now question is, first matter, when the hearing to be taken up by the director, they came before his lordship. His lordship directed him to attend the hearing of the director. He did not attend.
That is
Director-
Muhammad Abdul Wahab.
Abdul Wahab.
He did not appear before the director. Very well.
Director passed an order. That order, he challenged before this honorable court.
Very well. This is the item number 9.
This honorable court did not pass an interim order. Admitted the writ petition for affidavits. I have prepared the affidavits. Third matter is mine. I am moving fresh with regard to that order of the director for my claim to be decided by a writ of mandamus.
That is
In my-
item number 11. Whether item number 11 there are affidavits?
No,
My lord,
this is the first
only
time-
thing I am seeking before your lordship is that I seek time to file the opposition, my lord, if that can be granted, my lord.
I am praying for an interim order in my item number 11. I am praying for an interim order in my.
So why all the three matters is appearing?
I do not know who has mentioned how it has come. The item number 9 and 10, how it has come, who has mentioned, I do not.
9 to
I
11.
do not.
You mentioned this matter.
My matter, my lord, is filed before the department, file came before the lordship.
Let 9 to 11, I'm praying for a short passover. Mr. Raghunath Chakraborty is appearing. He's on his legs. He's just coming in 5.
He is appearing on behalf of item number 11. You are appearing item number 11.
And this is my affidavit of service in item number 11. And this is affidavit opposition, item number 10.
Item number 11 is appearing for the first time. 2025.
First time.
Okay. Okay.
For admission of motion. And then for interim order, I have prayed for substitutional transaction. Serious question of law is involved in this matter. Your lordship will consider the argument. That has to be canvassed by me. Of course, my submission would be subject to lordship and sanction.
And I
If these
seek,
three matters are hard today, then I have no objection.
Which matter?
These three matters, 9, 10, and 11.
Yes, I fixed matter today for
If-
hearing.
If it is hard, subject to lordship and sanction, I have no objection, I am ready. If your lordship feels that three matters will be hard on a particular day, subject to lordship and convenience, that is up to you.
in the meantime, some time will be given.
Now, what is the
I'll-
matter? What is the status of item number 9 and 10 regarding the affidavits?
My lord, I seek
In-
time to file the
In
opposition.
the item 9, 10, there are no affidavits?
No, item number 10,
Opposition
I have
matter.
got the affidavit.
to given, my lord.
You have got the affidavit.
I will file the affidavit in opposition.
Now, I want to know whether state has prepared any report or affidavit in the item number
I am for the
9 and
state,
10.
Malad.
I
I am for
cannot.
the state, Malad.
I
There
cannot.
is no.
That's why I'm asking whether you have prepared an affidavit or report in the form of affidavit like
I
that.
seek time before your lordship to
In
file.
item number, both item number 9 and 10.
Yes, yes. This matter is led by Mr. Swapon Banerjee, Malad.
For the state.
State.
It is in the. Affidavit.
Yes,
Then my 11, my item number 11 may be hard to take. This is my.
Lordship, for item number 9, I am filing affidavit in reply of the opposition filed by respondent.
9, I mean, 9, I did not appear.
But some time may be given to file the opposition matter.
no, the matter cannot be heard without the
Yes,
affidavits,
Malad.
I understand.
Yes, yes, yes.
So
Fine.
why
Some
there is no
time may be
direction?
given.
This is matter of 23. One is 24 and one is 25. This matter 11 is
23
25.
matter which is filed on 2023, report is filed by the state.
That's why I'm asking whether you have filed the report
And
you are saying.
it is also filed,
But
the
I
state
have
is complete.
I have, yes, Mr. Swapon
You are
Banerjee.
not there.
Malad,
item number
I have
9.
received the instructions from my senior that the opposition need to be filed, Malad. This is the instruction I have received, Malad.
opposition is not filed on item number 10, Lordship.
Item number 9 has filed.
Yes,
9 and 10 has been filed.
on 9, item number 9, report is filed by the state, Lordship.
Okay.
No one,
I did not have the instruction, Malad.
no one is aware about the
No,
status of the case.
Matters are jumbled up.
These matters are taken up
Be
together.
clarified by it.
কোনটা আছে বলুন তো 30
Item number 10.
30876
হ্যাঁ,
In item number
It is
9,
10.
whether I have a
Acha.
party, I have to examine because I did not receive.
10.
এটা 10.
Abdul Wahab, or whether Abdul Wahab is the respondent, I cannot say. Abdul Rauf. If Abdul Rauf is the party, then I will appear. Which is occupied. জানি না। Item number 10.
Item number 10.
10.
হ্যাঁ, 9 এর কথা বলছি।
আমরা তো 10 এ appear করছি।
এটা আমার কথা নেই।
10 এ আমরা
এটা হচ্ছে 10 তো
এটা 10।
What is the issue involved in these matters? No affidavit is there. No report is there by the state in item number 9.
হ্যাঁ, they are served the copy.
They serve.
We have, we have appointed.
Exception to the report. Can one
all প্রজেক্টটা বের করে নাম্বারটা দেন all
supplementary affidavit? No report is there.
আছে পুরোনো ম্যাটার নতুন
বিশ্বনাথ দেখা তো কোনো রিপোর্ট আছে স্টেটের রিপোর্ট
Matters of taxing for your lordship, let us come back tomorrow after going to the, because.
No,
we also-
every day
না,
we cannot talk.
হ্যাঁ
সেটা আপনি বলুন, আমরা-
আমি তো
It has to
বলেছি
be
আমি তো
heard.
বলছি sometimes so that the opposition could
4740 report file করেছে। Item number 9.
in item number 9, so far as I have checked the record,
Yes, yes.
no affidavit in opposition or reply is there, but
on behalf of the state
on behalf of the state,
My lord,
But
my
exception to
learned
the
friend-
report has filed.
my
That means
learned
you have
friend
served
said
upon
that,
them.
We have received lordship.
Yes, but in the record, there is no such AO.
ওটা কবে কার matter?
No reply or AO. No
2020.
report or reply, AO is there.
WPA 4740.
4740.
Yes,
My
lordship.
lord,
But the petitioner has placed the exception to the report.
Yes, lordship. We will
But where is the report?
my lord, maybe this is an old matter. It has been reassigned to us, my lord. This is the difficulty. This is item number 10 in regard to that.
Yes. In this matter, opposition is not filed.
In this matter. So that so the opposition to be filed, my lord. Some time may be given, my lord.
So why it is mentioned? And item number 10, there is no such report or nothing.
No, lordship. There is a direction on 9 January 2025 as per the lordship lordship Rai Chattopadhyay. This two petition is tagged lordship, and we mentioned this matter before you, lordship. And in this matter, Honorable Justice ordered to file opposition to the state as well as to the respondent number 9.
In both the matters, 9 and 10. Direction was there.
Only 10 lordship.
Only 10 what?
Opposition, direction of opposition is
Direction opposition is there is 9 also.
in
Yes, 9 is also there is direction. And they have served a opposition or report upon you.
Lordship, they have
But you have,
I
but they
filed
have
the
not,
exception of the report, lordship.
but no report is there in the record.
We have received the report.
10 is, there is also direction to submit the report in the form of affidavit.
Yes, lordship.
My
But
lord,
no such report is there.
for the benefit of my learned friend and my lord, that if the matter is taken after 3 weeks, so that I'll come back with instruction and with all the affidavit, my lord. If the
At best, the next week the matter can be taken up. If you not ready to file any affidavit or
my lord,
report, I shall conclude the hearing.
my lord, I have to file the affidavit, my lord, unless
They,
the
you have
affidavit-
served them, but
Yes,
not
my
placed
lord.
the record with the,
my
in
lord,
the record.
I'll serve them. My lord, maybe
You have already served upon them. Where is
My
the
lord,
report?
my lord, the brief is saying that it is item number 10, my lord. Okay. And my learned friend is saying that in item number 9, my lord, the affidavit has been filed, my lord.
Direction upon you in item number 10 is long back, not a new direction.
My lord.
Then-
My lord, sometime maybe
Why you
so
sitting
that
tight?
I'll file within a time, my lord.
No, what is the matter of item number 11?
The order is one.
Order,
One order is on challenge in 10. That order is under challenge in 11.
and 11 also the same order. You
Same
challenge the
order,
same
I'm
order.
challenging
So the matter had to be heard together.
together. And also, since the state government is appearing here, a question arises. The director passed an order for fresh declaration of the vacancy. Since the matter is your lordship, before your lordship, so that order should not be given effect to till your lordship heard the matter on merits. Because if the vacancy is declared, third party right will be created, then we will be non-suited. That's my prayer in item number 11.
Okay, come on 10th. 10th.
Then your lordship
Then
passed an order
other
for
time.
direction of affidavit. I am filing my affidavit in opposition.
I'm filing the reply, lordship.
10.
10.
Item number 10.
10.
Separate order for. Item number 10. Affidavit in opposition filed on behalf of the private respondent number 9 is taken on record. Affidavit in reply on behalf of the writ petitioner against the affidavit affirmed by respondent number 9 is also taken on record. Full stop. state respondent is yet to file any affidavit or report in the form of affidavit. State respondent is directed to file the report in the form of affidavit within 10th of March.
And
After supplying an advance copy to the parties, let the matter appear in the list on 11th of March under the same heading.
No.
10. 11 copy.
Fine.
No,
In
11.
item, in item number 11, this is my affidavit of service.
Just wait. You keep it. Item number 9. It appears from the papers that state respondent has not filed any report in the form of affidavit as directed earlier by this court. However, they have served the same upon the petitioner. Consequently, petitioner has filed an exception to the report. Considering the situation, let the matter appear in the list on 11th of March under the same heading. Item number 11.
11, I am filing the affidavit of service.
No, you just keep it yourself. I will take up the matter on 11th. Let the matter appear in the list on 11th of March. 11, I will take up the matter.
And one interim what I am praying before it also. Vacancy should not be declared. Fresh vacancy should not be declared.
Come on 11th, then I'll pass the order on 11th, not today. 11th of March.
11, my lord, I am praying for that interim order that vacancy should not be.
I'll heard your matter on 11th.
Oh.
I'll hear the matter from the state and I'll
No,
pass
I
the
think
order.
the state will not oppose. Kindly consider.
Have you served upon the state?
Yes, yes, yes.
Okay, come on 11th. I will take up the matter. All
No,
matter.
I think my learned friend or the state will not oppose. Kindly consider them, ask them, my lord. They cannot oppose my prayer. This is an innocuous prayer. Kindly see.
Yes. Are you appearing on behalf of the item number 11?
my lord, this matter
How
is led
cannot
by
tell him?
Mr. Papun Banerjee. My lord, I have only instruction to seek time before your lordship in the to file the opposition, my lord. This is the only.
What about item number 11?
My lord, I do not have the instruction about the item number
They have
11.
not
Only in respect of 10.
Come on 11. I understand the issue.
Monday,
Tuesday. Next Tuesday.
Next Tuesday.
as you know, sir. You also kindly remember my prayer.
Yes.
Remember my prayer. Because I made a prayer before the
I
court.
understand.
You also consider. And it is a prayer I am making before in presence of the state. They should.
No one representing state in item number 11 today.
11,
No, he is not appearing in item number 11.
Only in respect of 10. 10.
10, 11 again. Then since they are not appearing in 11, you will also kindly hear the matter export it. I will make it moving the repetition. Since the state is not opposing me, you will also hear my application. Subject to also conception.
No, if you want, I can hear it. No issue. Either I dispose of the matter on 11th. As the matter are connected, so I want to dispose of the matter on 11th.
Yes, yes. Let us see.
It would make a complication. You understand? Yes. Next.
In item number 12, I am appearing for the petitioner, my lord. Mr. Rabiul Islam is appearing in this matter, my lord. In the last occasion, my lord, the matter argument was heard on behalf of the petitioner in part, my lord.
This is part of matter.
Yes, my lord. Mr. Rabiul Islam is appearing. He is engaged in courtroom number 4, my lord. I am praying for kindly, if your lordship kindly fix it at 12, my lord. After
No. That cannot be done like that. Come on tomorrow then.
Yes, my lord. Come on then.
Not today. Next.
I am for 13. I am for the petitioner, my lord.
I am for the respondent number 14 and 15, your lordship, regarding this matter. I am appearing on behalf of the respondent number.
Item number 13.
13, my lord. It is in respect of the functioning of a union that is known as Southeastern Railway Men's Congress.
the point, my lord, for my initial argument that followed the election already over as per
My lord, I am petitioner, madam, I am petitioner.
already charge taken over.
No, madam, I am petitioner.
Office bearer should be hard, maybe hard. to be-
My lord,
Kindly
my
see
lord,
the office bearer.
my lord, if that, my lord, they have to file application before the
But kindly see the office
learned
No,
court.
let me hear the petitioner first. Petitioner is there. Why you issue? I shall hear.
bearer. Election already
Well,
completed.
let him. I do not know what is the issue here.
And railway authority told that election is void. It is not done
Yes, yes.
as per law.
You just
My
proceed.
losses kindly come to page 17. A suit was filed,
Page 17.
my lord. A suit was filed before the learned civil judge challenging the election biennial election of the Southeastern Railway Men's Congress in 2022. Several suit was filed. It was withdrawn by them due to the pressure of the my lord. Then lawsuits kindly come to page 18. Page 18.
Page 70 is a copy of a order, first order.
First order. And then next day, same date. That is not
It is suit for declaration and injunction
Yes, my lord.
before the civil judge senior division 6 court Alipur.
Yes, my lord.
Yes.
And that is, my lord, for the functioning of the Union Southeastern Railway Men's Congress, my lord. They told that the election biennial meeting held in 2022 is not valid. And then, my lord, losses quantity interim order passed. That is at page 19.
Defendants are hereby restrained from working as central office bearers.
Yes, central, they hold the election as
For
told, my lord.
violating
That was restrained. That is, they cannot function. And losses can see.
Who is the plaintiff? Who is the defendant?
Plaintiff is a member of the Southeastern Railway Men's Congress, and defendants that some of them are office bearer. They told hold the election in 2022 by annual general meeting, which is not valid, said by the court.
Yes, then what
As such,
happened?
then they file application for recalling of the them, and that is third, and on 19th August, my lord, that was, my lord, rejected. That is page 26. Page 26, it was rejected, holding that the interim order passed on earlier occasion in April, that is valid. 10th April, that is valid. That's happened, my lord. That the petitioners we petition under order 39 rule 3A and B of the CPC filed by the defendant number 3 and 13 are disposed of.
Yes, then what happened?
Then, my lord, they preferred appeal. Who preferred appeal, my lord? Let's just kindly see at next page, my lord, 27. Dipankar Rai filed appeal. He is only appealing. And the respondents, my lord, they didn't, my lord, office bearers and the railway. My lord. Southeastern Railway and authority. Then, my lord, filed in August 2023. Well, in the meantime, my lord, we have filed application before the, my lord, objection. That is, my lord, and in the meantime, what happened? I am submitting, my lord. There is another case of the Southeastern Railway Men's Congress. Then, my lord, this Honorable High Court in Southeastern Railway Men's Congress case, my lord, let's can be page 47. Page 47. Page 47.
Yes.
My lord, page 47. Reading me, my lord.
Carry on.
My lord, then let's page 47, 40, 50. My losses kindly come to 50. Well, 50, the Honorable Justice Kampa Sarkar said, I have considered the contentions of the parties. I have gone through the readings, and in my opinion, the justice would be subject if order dated 20th October 2020 is clarified and modified to the extent that the dependent number 1 to 6 shall not be allowed to perform as a activity of the office bearer, of the tribunal functionings shall enough to newly appointed office bearer till the disposal of the function. That is, my lord, another vision in 2020. And 1 to 6 is, my lord, lawsuits can come previous page at 49. 48, sorry, my lord, 48 from the top. Further declaration that the effect that the retired members of the defendant were 1 to 6. So lawsuit has sent that, okay, 1 to 6 is retired person, they are disallowed by Justice Hampa Sarkar. Let it go, that is in another case, my lord. Then, my lord, the interim order passed. Then, my lord, we have filed an application for transfer of the case from that ADJ to another, from landed ADJ to another. That is pending under Section 24. Page 53, my lord. First impugn order by the after 1 year, my lord, into the 18th September 2024.
In the miss appeal,
In the miss appeal. In the miss appeal, my lord.
which was filed against the order dated 10th of April 2023 in title suit number 478.
Yes, my lord. Miss appeal at page, my lord, 27, memo of appeal. And my lord, this is order, first order, after 1 year. More than 1 year, this order passed. All on a sudden, holding that, my lord, losses kindly go through it.
This is the impugn order,
First impugn order, then there's
page
another
53.
page 53.
Yes, what happened there? Page
Then,
53
today,
is the order.
he speaks for the further hearing of the above respondents. Both sides filed the advocate side here. One petition is filed on behalf of the respondent one for adjournment the matter till disposal of the miss case number SO for under section 24 of the CPC pending before the learned district judge Alipur as the next date of fix on 20th September 2024. That is for transfer, my lord. The copy of the learned advocate for the appellant is strong objection. It is submitted on behalf of the learned advocate for the appellant. Appellant, my lord, Dipankar Rai. That there is no stay in miss case number 406 of 2024 for transfer, my lord, that is. And as such, there is no implement in hearing the matter and pass the order. At that time hearing, some decisions are cited on behalf of the respondent number 1 as reported in the, that is, my lord, it is submitted by the landed advocate for the appellant that the respondent number it is submitted landed advocate for the appellant that the respondent number has challenged the order dated 11 order number 11 dated 19th October 2024 by filing a civil division, and yesterday the 17/9/2004 the civil division already has been rejected. That is not a transfer matter, came before the for early hearing, that is rejected. Next paragraph. As per the bylaws of the Southeastern Railway Bench Congress, biannual general election shall have to be completed within 2 weeks, and as such, at least election was held in 2020. That is wrong, my lord. We have challenged 2022 election. And that is about 4 years have already have been elapsed. And as such, as from the case record, it appears that many cases and proceedings have also been instituted which delayed the process of biannual general election in the Southeastern Railway Bench Congress. I have find that the matter cannot be proceeded in such a manner, causing the miscarriage of justice. However, it appears that the record, especially order number 11, 19th August 2024, the learned advocate appearing on behalf of the respondent number 1 is unnecessarily trying to delay the matter. Accordingly, having considered all the
Yes, it was logically permissive to make it short.
Yes.
The election has to be held. There is no controversy. We made an application, let the election be held under a neutral person, so to say, by special officer appointed by the court. That was refused. Kindly turn to page 56. Yeah. We want the election must be held. It must be held so that no future controversy arises about the procedure and the partiality. One petition is also filed on behalf of the respondent number 1 for modification of the order of election passed by this court for appointing special officer, either retired judge or CPOIR or relevant authority in order to avoid future complication for holding fair election of South Eastern Women's Congress. So and so, peruse the petition, heard both sides. As video order number 13, this court passed order of approaching election as per law. I do not find any cogent and convincing reason for passing any order for appointment of special officer. But the Honorable Court ought to have exercised its inherent discretion. If the election is the issue and that has to be held, nobody can, disputes that. Let it be held by a person against whom there cannot be any complaint in future. Because we have been seeing these elections are held always and some come to litigation. To avoid that, a special officer be appointed. I don't think anybody can object to this. And that special officer be appointed by the court. Anyone. We don't have any choice of person. This is the sum and substance of the whole issue. I didn't want to waste court's time.
That's my question. Supplementary.
And the election thereafter was held.
So your application was there for appointing a special officer.
Yes.
The application was turned down.
Turned down. Turned down, and the election has been held. And again, it arises that the election has been held in violation of the
Constitution of
Constitution of the Railway Union. They will let the election be held. Nobody can complain. Let anyone, any member of the bar, be appointed special officer to hold it. So that all the controversies may come to an end once for all.
Or the district judge.
That's what court could.
Or the data officer.
He was placing the earlier orders to show that this controversy has been continuing for a number of years.
What about the suit? What is the suit for?
That is not effective. That order is still pending.
That is only for the purpose of only in the election in twist compliance of the rules. We have found that the retired employees are coming over, which is not permitted under the rules.
Now, in the suit, there are admittedly one interim order is there.
Yes.
Whether you have challenged that interim order?
So the interim order is to the extent that the election will be held and the committee which was functioning till the election is held, new committee comes, they will function. Therefore, we have nothing to, we feel agreed on that. Kindly come to, once again, if I may refer, for consideration, order number 14 of 30th September refers that the court had passed an order for holding of election. As video order number 13, dated 20th of September, this court passed order for apposite election as per law. I do not find any cogent and convincing reason passing any other appointment. Therefore, the court also has opinion election should be held. Whether it should be held under the supervision of a special officer or not, that is the issue. And my humble submission will that cannot be and should not be objected by anybody else.
Yes.
But I being the appellant before the learned ordered appeal against the order for staying the conducting the election or the election already.
No, you have preferred appeal, that is Miss Appeal 300 against the order dated 19th of August 2023, wherein you wanted to vacate the interim order that was turned down. You preferred the appeal, Miss Appeal 300. In the Miss Appeal, in the Miss Appeal, your prayer was there, the interim order passed by the
election be held with the supervision of the learned additional learned judge. That Right, visualize color, 41,000 members in the railway, Eastern Railway, Southeastern Railway. Or then initially, the election of delegate. Or delegate election never challenged. Or petitioner, who is the petitioner before the lordship, but he is not at all a delegate. Or he is the only member.
Who?
The petitioner. Or who appointed, elected the office bearer. Or the delegate will elect the office bearer. Or member is not elected for the office bearer. Or 41,000 members.
Petitioner is the plaintiff before the learned court below.
Yes, well, he is the member. Well, he is not at all a delegate. Well, delegate election never challenged. If any person member challenge the delegate election, then will not challenge the office bearer election. Well, this is an office bearer election.
No notice was given to.
Yes, well, this is an office bearer election. This is not a delegate election. Delegate election already held, never challenged the delegate election. And also,
What is the prayer in the plaint?
Not an idea.
By general election.
Plaintiff কবিতা আছে? এর মধ্যে তো নাই দেখছি না। প্লেন্টের কপিটা তো প্লেন্টে কি প্লেয়ার ছিল ওটা করতে কি
this is the prayer, but kindly see.
General meeting.
The prayer was decree for declaration.
Yes.
That the alleged central office bearers in connection with the final ones who have no right to function and to act according to the alleged rules. Of declaration that the working committee meeting dated 23rd February and 24th February at Bihari illegal and void. Decree for declaration that the decision taken in biennial general meeting dated so and so are bad. Decree for declaration that any communication between the defendants and pro forma defendants regarding activity of Southeastern Railway void and bad in law. Decree of declaration that the last COB's two biennial general meeting dated so and so working committee meeting have no right to function on behalf of the Southeastern Railways Council. Now, basically, the biennial election is under challenge. That was the main point.
No, the direction is that the interim order, the defendants are hereby restrained for working as central office bearers by violating the Constitution of Defendant number 13.
Order still subsists. By that, they are not allowed to function. So thereafter,
So this is the interim order which is still existing.
By election already held, railway approved by the committee. Office bearer already, kindly see the office bearer election. And also, my lord, that appeal already disposed of after election and office bearer election. My lord, the challenge, my lord,
I just give a suggestion. I find, my lord, all of us are not totally prepared. Let me come back with the exhaustive list of dates, with the compilation of orders, which will be to lordship and all of us to council.
And also, my lord, kindly allow me to file a, my lord, affidavit in opposition, annexing, my lord, all these documents.
Do something.
Next week?
Let the matter be adjourned for 2 weeks. In the meantime, my lord, I shall prepare a compilation, let you file.
File affidavit, my lord, then
You are appearing?
I am appearing for on behalf of respondent number 14 and 15, Eastern Rail, Southeastern.
Respondent number 15 and 14.
14 and 15.
You use also affidavit if you want to use.
I think a dispute between the petitioner and the respondent number 1.
Okay.
Two unions dispute this. And answering respondent Dipankar Rai is here. At the exhaustive list of dates got a compilation.
Yes. Let the matter appear in the list on 19th. 19 is the Wednesday. Today we are on 4th.
It remains not. If I have some difficulty, I shall.
Yes.
I directly to file opposition.
Okay. Yes. The petition opposite parties are at leave to file opposition. opposition in the meantime by supplying advance copy to the petition. Nineteen, under the same heading. Next.
এটা বিকাশ
order has been complied.
Complied with. So it is not necessary to continue. Please take down. Learned counsel appearing on behalf of the petitioner submits that the answering alleged contemptor has already complied with the order of this court dated August 5, 2024. This is the order.
August 5, 2020.
Considering the submission of the learned counsel for the petitioner, it is not necessary to continue with the instant contempt matter. Let the contempt application be disposed of as infructuous. Next. Pass over. Next.
Lord, I beg to appear on behalf of my lord on behalf of the petitioner. কোনটা supplementary আপনার দুটো supplementary এখানে কেন দেখে দিন my lord subject to the leave of this honorable court I intend to file one supplementary affidavit incorporating certain document which was left out in haste, my lord. I have effected service upon my learned friend, my lord, that is relating to my lord document uploaded in the site of my lord the HPCL, the document lying with them, my lord. In order to show this particular document and to place before this honorable court, my lord, we have made this supplementary affidavit subject to correction. My lord, I have given copy. Now,
we serve a copy to them.
Yes, my lord. Yes, my lord. My learned friend is here. My lord, what happened in this case, my lord? It's a partnership business under Hindustan Petroleum Corporation. My lord, what happened? The partners were in a difficulty. They are not in a position, my lord, to, my lord, provide sufficient money for running this partnership business, as a result of which they have expressed their desire to take, my lord, partner, for which, my lord, the reconstitution of partnership is needed. My lord, I am drawing lordship attention, page 17, Memorandum of Understanding. By this document, my lord, we stepped into the, my lord, intend to step into the shoes, into the, my lord, the shoes of, my lord, a partner who intend to relinquish this partnership deed, my lord, partnership business. Page 17 may kindly be looked into, my lord, Memorandum of Understanding. My lord, third line between Shumona Dashrai, widow. Then, my lord, next page, page 18, Mrs. Shoma Dashmoitros, and at the bottom, my lord, Mr. Somnath Mondal. Myself is Somnath Mondal, my lord, and I have paid them, my lord. Lordship will find more than 1 crore, page 31. Page 31, my lord. It's 31. 30, my lord, paragraph 5. That party of the third part, Mr. Somnath Mondal, shall pay the remaining balance consideration money, if any, to the retiring partner, Shoma Das Moitro, upon approval of the reconstitution proposal of HPCL. By way of supplementary affidavit, I have shown that I have uploaded, my lord, reconstitution proposal. It is within the knowledge of the authority. Then, my lord, upon induction of the party of the third part, Mr. Somnath Mondal as partner of the partnership firm, Moitro Service Center, and upon necessary changes, partnership deed to the effect of induction of new partners, so and so, my lord. Page 31, lordship will find, my lord, from the box that I have paid 1 crore 10 lakhs to the credit of them, and page 32, another 47 lakh. Then, my lord, paragraph 8, I am reading that all the parties had to agree to follow the rules and regulation and let down procedure of Hindustan Petroleum Corporation Limited In regard to change of ownership in dealership, the existing dealers are required to follow the rules and regulation laid down procedure for change in ownership of the said retail outlet dealership of HPCL. Then, my lord, kindly come to my lord. Next document, this is power of attorney. That is page 43-44. My lord, page 43-44. This Shoma Das Moitro, my lord, this power of attorney has been executed. Kindly see, my lord, page 44, third paragraph. Now, on 14th day of April 2024, by this power of attorney, I, Shoma Das Moitro, executant herein, do hereby herewith Sri Somnath Mondal holding Aadhaar card number so and so, with power in my name and on my behalf to do execute the following acts, deeds, things, and all these things. My lord empowered me, my lord, to do the things. Then, my lord, lordship will find, my lord, page 45, to supervise, manage, para 3, conduct operation of the said business according to the dealership agreement with Hindustan Petroleum Corporation Limited, to apply government, semi-government rules and regulation in so far running of the business is concerned. Then, my lord, I have application for reconstitution of the commission dealership, that is vital, page 48. My lord, at the top, my lord, date 17/4/2024. Then in middle portion, lordship will find the name of Shoma Das Moitro. Lordship got it. At the middle portion in box, my lord. Up in clause 2, details of existing diseased incapacitated proprietor partners. Then, my lord, Shoma Das Moitro. Then, my lord, category others. Then, my lord, alive, existing share 50%. My lord, wish to continue retire. And my lord, Shumona Das Rai, the other partner, will continue. Next column. So, my lord, Shoma Das intend to relinquish, and my lord, Shumona Das will be there. And in place of my lord Shoma Das, Somnath Mondal, the petitioner herein, intends to, my lord, into the partnership deed and to do this business. Page 57. Whether reconstitution proposed for the induction of outside partner. Lordship got it? Page 57. 7. A. Whether reconstitution proposed for induction of outside partner. Answer is yes. So, my lord, then my lord, lordship will find page 52. This is relinquishment of Shoma Das Moitro in favor of first paragraph Shoma Das Moitro. She is relinquishing. Paragraph 2, Somnath Mondal, aged about so and so, residing at 122B Hemchandra Noskar Road, Kolkata 10, West Bengal. We request Hindustan Petroleum Corporation Limited to kindly accept this relinquishment deed letter from our side. So, my lord, what we are doing in terms of the provision of the, my lord, of the company for reconstitution of partnership, one partner is relinquishing this particular business, another aspirant intend to come within the four corner of partnership to run the business. Then, my lord, lordship will find, my lord, first class magistrate, page 53, this Shoma Das Moitro, who intends to retire, my lord, by swearing this affidavit, very categorically stated, page 54, 1, last line, memorandum of understanding dated so and so, entered into by and between the said Shumona Das Roy, Mr. Somnath Mondal, and myself. Then, lordship, kindly come to, my lord, a letter addressed to, my lord, Shumona Das Rai, my lord, written by my client's lawyer, and there was a reply, page 16. But Shoma Das Moitro, my lord, her lawyer, my lord, said, lordship will come to, my lord, kindly come to, my lord, page 61. After skipping 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. However, Shoma Das very categorically stated, lordship got it after leaving second paragraph, 10 line, lordship will find, however, regrettably,
page 61.
First paragraph, my lord, not. Second paragraph, pursuant to the execution, started. Yes. And my lord, after leaving 10 line, kindly come to, however, regrettably, Shumona Das Rai, the other partner, withheld her NOC. citing due to receipt of a legal notice in connection with an application of Section 9 of Arbitration Act 1996. My lord, it is written on, lordship will find page 60, 17/11/2024. My lord, without indicating that as to whether, my lord, the arbitration court granted any interim order. Even if interim order is granted, lordship knows, my lord, after a certain period, my lord, Section 70 will be applied. Then, my lord, this arbitration proceeding, 9 proceedings will be automatically, my lord, will go because of, my lord, entering into the scene, and, my lord, anything, my lord, to be prayed for, that to be prayed for in another provision of the Arbitration Act. Here, my lord, citing due to receipt of a legal notice of Section 9. So, my lord, we don't know what was the outcome of this legal notice, whether there is any, my lord, miscase before the arbitration court, my lord, under Section 9 of the Arbitration Act, whether there was any stay order, whether someone entered into the scene, whether Section 17 proceedings has been initiated or not. Simply, my lord, the indication is Section 9 proceeding is there, as a result of which Shumona Das Rai, my lord, is reluctant to, my lord, do something in favor of myself or reconstitution of this partnership. Then, my lord, kindly come.
Issuing no objection.
Yes, my lord. No objection. Kindly come to page 62, second paragraph. That the contention made in the second paragraph of the said legal notice dated so and so is denied and disputed by my client, same and except what are matters of record, and it is stated that my client had explicitly expressed her intention to retire. Shoma intends to retire, and, my lord, myself intend to enter. Company is well aware, but Shumona standing on the way, and our specific case is, my lord, there is a collusion in between company and, my lord, this Shumona, as a result of which this partnership firm is yet to be constituted. Then, when I am coming, my lord, Mrs. Moitro Service Center, as per prior agreement and memorandum of understanding dated so and so, this desire was formally communicated to the Deputy General Manager Petroleum through a representation of so and so made over by my client. My client remains willing to facilitate the necessary measure for induction of your client as the new partner. However, it is emphasized that my client bears no responsibility for the delay of induction of process, which is solely attributable to Shumona Das Rai, unwillingness to provide requisite NOC, reiterated that my client has fulfilled her obligation and is not responsible for the delay in the constitution process. Then, my lord, kindly come to next paragraph, leaving three line. The representation requested the extension of reconstitution deadline. However, the authority concerned respondent via letter dated so and so, stating that the reconstitution proposal was closed online due to other partners' refusal to provide consent. Whether, my lord, other partner can stand on the way with a flimsy, my lord, the plea taken by him or her is a flimsy one, because Section 9 notice is there, whether Section 9 proceedings has been initiated, whether there is any stay, whether someone entered into the Section 9 proceedings, whether Section 70 has been initiated or not, this is required to be adjudicated by the company itself. No, this cannot stand in any manner whatsoever. This cannot be the ground for, my lord, this cannot prevent the reconstitution of partnership. That decision is yet to be taken by the company, my lord. Then, my lord, I am coming. Lordship, kindly see, my lord. I am not, my lord, I don't want to consume much more time. Lordship will come, my lord, page 65. Page 65, my lord, initial agreement. My lord, lordship will find, my lord, only one thing, my lord, before going into that particular page 60 may kindly be looked into for a while, my lord. Page 60. Second paragraph, last few lines. Accordingly, the partners of the above referred retail outlet approached your client. Lordship, got it? Page 60, my lord, annexure P6. 17/11/2024.
Yes.
My lord, leaving away 7-8 line, my lord, accordingly, the partners of the above referred retail outlet approached your client for financing and to ensure continuity of the business, whereby your client had accepted the offer made by the partner. Kindly see, my lord, the continuity of the business. This is for the public purpose, and this public purpose, my lord, their financial crunch is also there. They are not in a position to run the business, and that particular offer was given. My client has accepted it. And this public purpose, my lord, trying to frustrate, supposing this is not reconstituted, it will be fresh vacancy. Something will be difficult. The people of the locality will be in trouble and all these things. And my lord, that being the situation, they are in financial crisis, as a result of which they have decided to take a new partner. Then my lord, I'm coming, lordship, page 65. Page 65, my lord, 66 at the bottom. Duration of agreement. Kindly come to my lord. The provision of termination is also there. My lord, leaving 3-4 line, in respect of any matter or thing antecedent to such termination, provided that nothing contained.
You are reading page 66.
66 bottom, my lord. Duration of agreement.
Yes.
After leaving 3-4 line, my lord, I'm reading. By giving 90 days notice in writing to the other of his intention to terminate this agreement, and upon the expiration, but I intend to show, my lord, there is a provision of termination also. Then lordship, kindly come to my lord. This is, my lord, the retail outlet dealership agreement. Then kindly come to my lord, page 73 at the bottom. Page 73 at the bottom, clause number 45.
Yes.
The dealer shall not enter into any agreement, contract or understanding whereby the operation of the dealer herein may be controlled, carried out or financed by any other person, firm or corporation, whether directly or indirectly, whether in whole or in moitro service. Then my lord, the dealers or proprietor firm, trust and cooperative society private limited shall not effect any change in its constitution, whether by induction of partner in the proprietorship or in the identity of its, come to my lord, next page, existing partner, member of the shareholding or any of them, or terms of the deed of partnership or bylaws, trust, or in the event of death of any partner, firm, member of a firm, cooperative society which has been appointed by the dealer, so and so, my lord. My humble submission before this honorable court, change of constitution, even if anyone intends to do, permission is required to be taken from the appropriate authority. Then my lord, 46, dealer to bear expenses, observe local and other laws, leaving 4-5 line, the dealer shall also be liable, also solely liable for the breach or contravention by himself, his servant, agent of any laws, rules, regulation, bylaws passed or made by the central or state government, so and so, my lord. Then kindly come to my lord, next page, page 75 at the bottom, the termination clause, when this termination will take place, page 75, 76. I'm reading from 76, my lord, at the top. If the dealer contains a breach of any covenant stipulation contained in the agreement, 1. If any attachment is levied, I'm not reading everything, but I'm coming straight away to F. If the dealer for any reason make default in payment to the corporation full or outstanding as appearing in the corporation books and account beyond the 4 days of demand by the corporation. Then my lord, I'm reading GH, the dealer sells the product supplied by the corporation or price higher than those fixed by the corporation statutory authority. The dealer either by himself or his servant or agent commits or suffered to be committed any act in the opinion of the chief senior manager of corporation, the timing in Kolkata, which decision shall be final, prejudicial to the interest of the good name of the corporation, or my lord, showing corporation they are collecting money. My lord, provision of reconstitution is also there, and my lord, they are inviting us to be their member. They are in a financial crunch. And I have entered into keeping in the mind that the company is the HPCL. My lord, the company, my lord, it is state and its instrumentalities. As a result of which I entered into. And my lord, they are trying to use their good name, exploit the good name. And my lord, the company is sitting tight and looking it as a my lord, as a mute spectator that something is going on, taking their name. They are not taking any action and all these things, my lord. Then, my lord, I'm coming, my lord, page 76, 55. Failure to uplift product and operate the outlet. Then, my lord, kindly come to, my lord, page 77, auto termination agreement. Kindly come to, my lord, page 77, 55, Roman 4. A, death of a dealer. Retirement, my lord, one intends to retire. Induction of any partner without any written consent of the corporation. My lord, this is a process of taking written consent. And it was uploaded, every document was uploaded. And they are not doing anything, taking the plea, a certain time has been lapsed. And my lord, one of the partner who intends to, my lord, retire is reluctant to do the same or retirement because of one Section 9 Notice of Arbitration Act has been initiated against him. Our humble submission, my lord, it cannot be a plea, my lord. No stay order is there, nothing of this sort. Now, arbitration proceedings, my lord, the final proceedings is to be taken place in an appropriate manner by invoking the appropriate section, not Section 9. For interim order to protect the property, from wasting, my lord, sometime, my lord, this particular clause is applicable. Then, my lord, kindly see, my lord, insolvency. Then, my lord, see, insolvency of the dealer or any partner in the dealership firm. Lordship, they themselves indicated their financial crunch is also there. And, my lord, this can be a cause of auto termination. In the instant case, there is no auto termination. He has collected money from us and deposited to the company. And, my lord, trying to run the business in her own name, taking my money. And company is aware of it. Company is not taking any decision. We wrote them on several occasions. That representation is still pending with the company. Company, for the reason best known, my lord, playing a role of mute spectator. It is least expected from state and its instrumentalities. Then, my lord, kindly see, we wrote a letter, my lord. My lord, kindly come to page 88. Kindly come to, my lord, page 88. Addressed to, my lord, the chairman, Hindustan Petroleum. Now, my lord, every incident is, my lord, narrated. My lord, we are trying to draw the attention of the highest authority. My lord, one reply you have received, not from the chairman, but from the learned advocate of the company. Page 94. Here, my lord, page 94, third paragraph. Answer, it is specifically stated that my client has no knowledge regarding your contention to the effect that partner of the Moitro Service Center approach your client for running retail outlet, namely so and so. My lord, we have downloaded each and every document, that is by way of supplementary affidavit. And, my lord, they are aware of it. Someone is going to retire, someone intend to enter. A partnership firm cannot operate without the partner. It is not, my lord, a single person cannot run.
Certainly, you have not provided, you have not collected the no objection.
My lord, no objection because of flimsy ground, no objection.
May be ground.
My lord.
Fact is that you have not received the no objection.
My lord, that ground, Section 9.
How can you bind the authority now?
Because authority, the plea taken by the authority, lordship, kindly see page 94. It is specifically stated, emphatic. It is emphatic that my client has no knowledge regarding your contention to the effect that partners of Moitro Service Center had approached your client for running the retail outlet, namely Moitro Service Center. They were aware, my lord. I will show from the, my lord, supplementary affidavit. And, my lord, that particular document where one is intends to retire and other will continue. Then, my lord, one partner will come into the scene. And, my lord, they are not aware. This plea is a flimsy plea. This plea cannot be taken by a company, my lord, who are the instrumentalities of the state. Then, my lord, kindly see, my client is also not aware of understanding of whatsoever nature between you and your partners and the partners of Moitro Service Center for relinquishment of the share of Shomadash Moitro against payment of any money and so and so. Then, my lord, kindly come to page 95 at the bottom. It is submitted that the reconstitution of dealership is permissible, can be carried out by following the reconstitution policy guideline of the oil company and the procedure followed by the oil company. It is, however, a fact that the partners of Moitro Service Center had submitted a reconstitution proposal, but they did not proceed with the same for the reason best known to them. But on the one hand, it is clear for Section 9 of Arbitration Act, one notice is there for that. And here, my lord, for the reason best known to that partner. That is the answer from the learned advocate of the company. Then, my lord, I am showing, my lord, the supplementary affidavit. Lordship will find, my lord. My lord, this is supplementary affidavit. Lordship, kindly see. They are denying that such things is taken place. This is beyond their knowledge, my lord. Lordship, kindly come to Annexure P11, page 4. This is a Google account, Moitro Service Center. Then turn to next page, page 5. Reconstitution application. Lordship, got it? Document uploaded. Page 5 of supplementary affidavit.
Yes.
Reconstitution application, copy of last distributionship agreement, copy of existing partnership deed. Then, my lord, it's going on reconstitution detail. The next page, reconstitution detail, detail of the existing constitution. This is we have uploaded. Lordship will find, my lord, page 8, page 9. Page 9, Lordship will find one is Shumona Das Roy.
Yes.
Second is my name. Detail of the proposed constitution.
Yes.
I am not well.
No, who your matter?
My matter is item 30. I am not well. Kindly.
No, very well. Item number 13. Item number 30. So when it can be, I can. Tomorrow. Tomorrow, same heading.
Tomorrow, kindly.
Shall I fix it early?
Morning.
Morning 10:30. Okay. Just wait. I'm just fine. On mentioning this matter, I don't know. 30. No, I'll put this matter in mention matter. First 3-4 matters. Within first 3-4 matters.
Then let it appear in the same condition. Let us keep that in that.
Okay. Let the keyboard.
And if I can't come, I can't come. Not well. I am not.
No, very well. Very well. Just this matter be appear under the heading. Under the heading mention matter. Mention matters. Tomorrow. Mention matter. Item number 30. Item number 30 order of it.
Then, yes. Then, my lord, page 9.
Yes.
Shumona Das Roy and my lord Somnath Mondal. My lord, my name is there. Detail of the proposed constitution. We have downloaded all this paper from their, my lord, server. Is it downloaded? And we, at a point of time, it was uploaded. That is why, my lord. This is beyond their knowledge, my lord, cannot be. Then, my lord, page 10, documents uploaded. Every document details are there. Then, my lord, kindly come to, my lord, page 12, list of all. Lordship will find from page 15, my photograph.
So your submission is that everything has been uploaded.
Yes.
But ultimately, you have not properly followed the guideline. That is the reconstitution of dealership.
No, my lord, that is that particular order is to be passed by the authority. They are to pass. It cannot be by a lawyer's letter. So what we are seeking, my lord, the authority should look into the whole issue, including the question of section 9, and to pass a reasoned order. Finish, my lord. I intend to rely upon 2 judgment, my lord. 2-3 minutes. Kindly come to, my lord, page 15.
Yes.
Here, my lord, continuing partner photograph. Clause 2. Continuing partner. And then, my lord, after the photograph, lordship will find the continuing partner. That is Shumona Das Roy, page 15. And the next photograph is mine. At the bottom, incoming partner.
Yes.
This is, my lord. Then lordship will find, my lord, my letter once again, my lord, to the address to the Deputy General Manager that they have received, my lord. Our humble submission, my lord. My lord, we think, my lord, there is a nexus to some extent. We have followed all the formalities and we have submitted all this before the authority that is pending consideration by the authority. Authority at least should come forward, at least to provide us a, my lord, reasonable opportunity to argue before the authority and to pass a reasonable order. My lord, I am relying upon a judgment. Lordship knows, my lord, 2010 8 Supreme Court cases, that is Salini Sam Shetty versus Rajendra Shankar Patil, page 51-57. Page 51-57. My lord, this is for the public purpose. This is, my lord, a petrol pump for the reason, to facilitate, my lord, the common people to get the benefit of petrol, my lord, and all this, my lord, the petrol firm used to be established, and they are facing, my lord, the financial crunch. It may be auto termination, it may face auto termination. I have provided money, taking that money, running their running business, but in spite of all assurance and agreement and affidavit, my lord, someone is standing on the way, and corporation and the my lord, the oil company is also supporting him. My lord, paragraph 51 and 57 may kindly be considered. These two paragraphs mean for the, if there is any nexus in between, my lord, the government and.
How can you prove the nexus?
My lord, they are sitting tight simply. My lord, I have.
Yes, and until
Lordship.
they fulfill the guideline of reconstitution, they would not.
My lord, we have it is uploaded.
Bound to take any steps.
My lord, we have uploaded.
Yes, you have uploaded sufficient document.
So they are to.
They are required to you are required to submit some other document.
No, my lord. My lord, at least they should come forward and to say these.
Why they should come forward?
No, my lord, in the event.
Why they should come
in
forward?
the event there is any difficulty in
No,
the.
if you want your application to be heard, that is the other issue.
I may be allowed. My lord.
Altogether.
No, this is there is no other issue.
You cannot.
There is no other issue, my lord.
That the reconstitution policy has to be carried out.
What is their reply through their lawyer, my lord? I am once again reading page 94. Page 94. Kindly see, my lord. What is their reply?
That they are not.
Did they take this plea? Though you failed to produce all relevant document, as a result of which you are not considering your case. Page 94. I just read it. 2 minutes. Page 94, my lord.
Let him finish.
Third paragraph. It is specifically stated that my client has no knowledge regarding your contention to the effect that partners of Moitro Service Center had approached your client for running the retail outlet, namely Moitro Service Center. So who is the continuing partner and who will be, my lord, the incoming partner? I have uploaded all the document and that is lying with them. And this cannot be the plea. That is why the stand is required to be taken by the appropriate authority, not by the lawyer.
What they said.
Kindly see.
They had no knowledge regarding you, whether they had approached you.
Yes, my lord.
That is the.
Otherwise, my lord. Otherwise,
all matter they are within.
Otherwise, my lord, how can a new partner enter into the scene?
Maybe you may approach.
Yes, I may approach.
Yes.
Yes, I may approach.
Knowledge regarding who have approached.
So different question. That is why proper adjudication. That is why proper adjudication is required to be made by them.
So what you want?
I want, my lord, my representation which are pending before them, my lord, is required to be considered by the appropriate authority. This is one aspect and only one judgment, my lord. Only one judgment. This is Salini Setti's judgment, my lord. Lordship will find from paragraph 51 and 57. My lord, may be applicable, may not be applicable. Lordship will, my lord, decide whether this is any nexus or not. My lord, I intend to rely on the other judgment.
Page 50 in this 2010 8th SCC.
At the top, my lord, the paragraph I have mentioned. I have to save time, my lord. I am not reading all this. This is reported judgment, my lord.
Salini Setti.
My lord, kindly see this copy I require to hand over to my learned friend because this is. My lord, in another matter, very recently, my lord, Honorable Division Bench of Justice Devanshu Boshak and Companion Justice, my lord, passed order. That is MAT 1828 of 2023. Copy আছে আপনাদের কাছে? আচ্ছা এটা কপি আছে? I দিয়ে দিচ্ছি, এটা unreported দিয়ে দিচ্ছি। 1828 of 2023. 2023 Orupaj. Paragraph 16, my name is just reading. Appellant before us lodged a complaint dated so and so with the oil company where the appellant alleged they invested a sum of rupees so and so amount purchase of godown land making construction of infrastructure. Out of the said amount so and so was paid through bank so and so. It was also alleged that there was a partnership agreement executed for non-judicial stamp paper on so and so, recording of equal share between three partners, namely so and so. The complaint goes on to say that there was a scheme of regularization floated by the oil company. Then, my lord, I am reading paragraph 35. The money being paid to them, and my lord, they are not responding, and as a result of which there was a complaint before the company, and company was taken up the matter and to decide whether that was properly done or not. Here also, my lord, we are drawing the attention repeatedly that we have paid a huge amount, and my lord, someone is standing on the way not to allow us to enter into the partnership firm on a flimsy ground. Whether it is flimsy, whether it is required to be adjudicated by the appropriate authority or by the lawyer, that to be decided by this honorable court.
No, only one question I just
Lots,
want to
lots.
want to- whether these are the duty of the authority
Because
to look into the dispute between the private
no,
parties.
because taking the name of the authority,
Yes, maybe,
everything
maybe taken
every-
the name.
and they have taken
Maybe someone taken the name.
and take and they we have to pay them.
No, one person running a business of dealership.
Kindly see page
He has taken 5 crore
No, Lordship,
from
kindly,
one person showing
Kind-
that you would be given license, you would be given
kindly see
license.
page 5 of the supplementary evidence for a while. Page 5.
No, I have
No, one document, only one document. I will not argue a single line. Page 50, page 5.
Page 5.
Page 5, Lordship, kindly see address, transaction reference, and then Lordship got 25,000
Document uploaded. List.
Page 5. Annex.
Document uploaded list.
Yes. At the top, my lord. Page 4, annexure P11, 4, then 5. Page 5, Lordship got it?
Yes.
Kindly see it from the top. Address so and so, transaction reference so and so, amount paid 25,000. They've
Yes.
taken money for the processing, for the processing of all this thing, my lord. For the processing of
So
this
you-
amount is also lying with
what you want?
my lord, I want they should
They have placed the money for the purpose of reconstitution
yes,
policy.
yes, my lord.
So you have taken part in the policy.
Yes.
But finally, admittedly, you have not concluded the policy.
No,
direction.
my lord, that is required to be made out by them. This is the difficulty. My lord, that is why we are asking, my lord, let them direct to consider, subject to correction. We are beseeching, my lord, subject to correction, let them adjudicate the whole matter. After adjudication, they may reject it. I think, my lord. This is not, my lord, something we are expecting.
Okay.
Lord, deeply.
Okay. Yes.
Lord, kindly see page number 95, the reply of the company. Page number 95. My client is also not aware of the existence of any memorandum of understanding mode dated 14/4/2024 alleged to have been executed by and between the partner of Moitto Service Center and your client. It is categorically submitted that my client is not aware of any sort of financial help by your client to the partner of Moitto Service Center, and it is also not aware of execution of move between your client and the partner of Moitto Service Center for whatsoever purpose it may be. Milord, in the said policy, after for any dissolution, the partner of the said firm have to inform the company, and company will take necessary process to dissolution of the partnership and entry reconstitution of another partner.
What are the requirement of the reconstitution policy?
I will file a affidavit in opposition stating everything, Milord. All the purpose.
Only one question, whether they have taken 2 crores from us or not.
Milord, who has taken? The Soma.
My lord, so far as oil company is concerned, he is appearing on behalf of the private
Yes,
responsibility. May not be aware of.
Yes. And now,
Yes.
May I just clarify? Whatever.
Okay, he is appearing for the private response. Okay,
yes, he has taken money.
No, Milord.
May I just?
okay, just wait. Let me.
That why I have stated, because my I was replying that there was initially a memorandum of understanding. Oil company was not aware of all these things, that the money has been transferred from a third person to this particular person. Whether under the partnership or running the business or not, that I don't know. That was completely without permission and behind me. That was done. Subsequently, they have entered into whatever document that was not enclosed. I repeatedly submit without with instruction, my lord, that the supplementary affidavit file shows only the documents uploaded. They have not uploaded this memorandum of understanding, which is at page 17. That was completely, yes, that is memorandum of
No,
understanding.
they have page 5, draft copy of dissolution deed of existing.
Yes, but that is not the, this is not the memorandum of understanding.
That is not the memo.
Memorandum of understanding, no. That is page 17. For the repetition, your lordship will find That is the memorandum of understanding.
Yes.
That is not a format in the prescribed format for running the dealership in a partnership, proposed dealership. This is completely different. In the event they suggest that they have supplied a copy of the partnership, let them produce. There was no partnership, reconstitution of the partnership, reconstituted partnership for that was never signed, nor was placed. That was the proposed that this person will come instead of this one. That was the reconstitution policy for which it was filed. 25,000 was filed for the purpose of the
Reconstitution policy.
Reconstitution policy. Now may I one by one, my lord. The paragraph, page 17 shows that memorandum of understanding by which money has been transferred from a third party to these dealers, my lord. That was not within my knowledge. I have categorically stated that they have nothing is on the record to show that this particular memorandum of understanding was placed before HPCL at any point of time. Or the power of attorney at page 43. Whatever has been placed, I will place. Let them show that any document, so far as memorandum of understanding or the power of attorney has been uploaded for reconstitution. I will come later on. So first memorandum of understanding, they have entered into at their own risk. We were not party to that agreement, nor we were informed. Secondly, power of attorney at page 43, your lordship will find.
Yes.
That was also not placed before HPCL. This was the document entered into by Somnath Mondal, the petitioner, along with the dealers in their individual capacity. Now, they may take loan or for any money for their own purpose. This is the first thing, whatever money. Thereafter comes a proposal from the existing dealer that they want to reconstitute. That is completely different, my lord. Not on the basis of that memorandum of understanding. They have expressed their intention that one of the existing partners will retire and this Somnath Mondal will enter into her shoes. So they have filed a reconstitution proposal. Now, during the reconstitution proposal, when it was pending, my lord, it provides that the person concerned will have to appear before the concerned authority of Deputy General Manager for interview, that whether they are eligible or not. My lord, one of the existing partner did not appear, for which I have categorically mentioned, for which the reconstitution policy was dropped. Now, we cannot force somebody, dealer or respect, that you will have to be a partner with that particular person. That is their choice. If the proposed person fulfills the eligibility condition, their reconstitution policy may be proceeded with. Now, I cannot force a partner that, yes, you will have to be a partnership, have a partnership with that particular person. This is one thing. Secondly, they have on their own, the partners who have proposed to reconstitute, they have withdrew the same. They didn't proceed with the same. Now, what can we do? It is their choice whether to proceed with or not. What order we will pass on that basis of the same. Well, this is one aspect of the matter. Now, so far as the reconstitution policy, what has been filed with the supplementary affidavit, my lord, that is the document existing partnership and the proposed partnership. Nothing has been mentioned in so far as memorandum of understanding or transfer of money from one party to another has been mentioned.
Yes.
Now, first, your lordship will see page number 5, my lord, uploaded document.
Yes.
Constitution application. Thereafter, copy of the last distributorship agreement. That was
Existing.
Copy of the existing partnership deed, that is between the two ladies. I mean, private respondent. Draft copy of dissolution deed of existing partnership. Draft copy of deed of proposed partnership. Now, all this speaks of partnership, my lord. Nothing is with regard to this memorandum of understanding. Let them show that they have produced the copy of memorandum of understanding. That was never placed. And why I have written that I will show from their letter and my reply to that. I will come to that. So these are the documents they were uploaded, my lord. Nothing is on the record to show that memorandum of understanding was uploaded. Be that as it may, it is their wish and will to continue with the reconstitution policy or not. Now, so far as there are two aspects, third party has staffed off nearly, as per their representation, that half of nearly 2 crores of money. That is at his own risk and will. We were not informed about that. No permission was taken. First, second, my lord, your lordship will come to that representation of the learned advocate on behalf of the writ petitioner. That is at page 88, my lord. On what basis I have learned lawyer on behalf of the company have replied to the same. That is page 88 of the writ petition.
Yes.
Now, second paragraph, your lordship will see this is to bring to your kind attention that somewhere during November 2023, the aforesaid partners of Moitro Service Center, namely Shumona Das Roy, Shuma Das Moitro, and her husband Shomodip Roy, had approached my client Sri Somnath Mondol, son of late Arun Kumar Mondol of such and such, with an offer to be a partner of their firm and run the petroleum dealership business as a dealer of HPCL and extend financial help. Kindly look here. Financial help to the partnership firm for running the dealership which is facing acute financial crisis. Now, how do I know that? Whether they have asked for financial help, that is cannot be within my knowledge. For which my letter, company's letter rather, at page 94, second paragraph.
Yes.
It specifically stated that my client has no knowledge regarding your contention to the effect that the partners of Moitro Service Station had approached your client for running the retail outlet, namely Moitro Service Station. My client is also not aware of any understanding, that means memorandum of understanding, of whatsoever nature between you and the partners of Moitro Service Center for relinquishment of share of the Shoma Das Moitro against payment of any sum of money for relinquishment of a share and interest in the partnership firm as alleged. Because, my lord, in the continuing paragraph at page 88, my lord, your lordship will find there are specific allegations that money to the extent of 1 crore 45 lakhs has been transferred. Now, how do I know that? That is not within my knowledge. That's why this is the contention. The lordship kindly goes to my letter in its totality to understand my. Now, page 2 specifically states, my client is also not aware of existence of any memorandum of understanding dated such alleged to have been executed by and between the partners of Moitro Service Station Center and your client.
Yes.
It is categorically submitted that my client is not aware of any sort of financial help advanced by your client to the partners of Moitro Service Center and is also not aware of execution of any loan, specifically states, between your client and the partners of Moitro Service Center for whatever purpose it may be. So I have categorically mentioned it at home, not a partnership agreement. We were not aware of that. Let them show that they have at any point of time uploaded this move, memorandum of understanding. Now it has been now next paragraph at page 95 is submitted that move, if any alleged to have been entered upon by the partners of Moitro Service Center has been done by the partners of Moitro Service Center in their individual capacity and not as a dealer of HPCL, functioning under the terms of the dealership agreement dated such entered upon by the partners of dealership with the firm. The parties to the purported agreement has entered into such agreement on their own risk and consequences, and if any dispute arises amongst themselves in connection therewith, the same may be settled by them by taking up the issue before the court of law having appropriate jurisdiction or before any other forum as may be advised. HPCL, as a matter of fact, have got nothing to do with regard to the dispute arising of the agreement entered into upon by the parties or any amount of money advanced by any of them to others, which is completely unconnected with the dealership agreement dated such existing between HPCL and Moitro Service Center. Now, very important that has been highlighted. It is submitted that reconstitution of dealership is permissible and can be carried out by following the reconstitution policy of the oil company and the procedure followed by the oil company. It is, however, a fact that the partners of Moitro Service Center had submitted a reconstitution proposal, but they did not proceed with the same for the reason best known to them and for which the proposal has been dropped. HPCL under its rules, guidelines, policy have no power to force the partners of the dealership firm to get the dealership constituted by inducting your client as a partner of the dealership firm. It is just between whom they will form the partnership. Your client contention, next page.
Yes.
Your client contention to indicate that HPCL is aware of any fraudulent practice of the partners of mutual service center is absolutely erroneous. Your client may be instructed to establish his contention of commission of fraud on behalf of the partners of mutual service center before any court of law having competent jurisdiction. Because, my lord, I cannot decide whether there is any fraud. In view of the fact that the government, if any agreement, arrangement, if any entered upon by your client with the partners of mutual service center is in their individual capacity and the same is in their personal arrangement, HPCL has no business relation with your client. Specifically denied that mutual service center is done by a third party for running the business of HPCL. Has allowed the firm to run illegally to protect the mutual interest of HPCL dealership as alleged. It is still denied such and such. Now, my lord, can you see that what we can do after receiving that particular complaint? We have initiated, that is upon instruction, my lord, that can be recorded. They have issued a show cause notice to the partners, my lord. No formal decision has been arrived till date, my lord. Unless it is proved that there is a fraud, that is a specific clause in the dealership agreement that if fraud is proved, the dealership can be terminated, my lord. Unless any of the grounds are attracted, my lord, for which dealership can be terminated, we cannot do. Now, my lord, so far as the judgment passed by Honorable Justice Substitution in the substitution bench is concerned, my lord, your lordship will find there was already a partnership form. In this case, there was no partnership form. That is a proposed partnership, subject to approval of the Reconstitution.
Yes.
Now, my lord, one thing my learned friend has asked, my lord, I think that will suffice, my lord. Since there is a representation, let there be a consideration, giving an opportunity of hearing.
Yes.
That will suffice, my lord. Since I don't know whether any error has committed, let them establish the same.
Very well.
As an authority, we can do it.
Representation at page 88.
The logical is we cannot direct somebody.
I understand. I understand. Page 88. Representation.
Representation, my lord, and also supplementary.
Page 88.
Lordship, kindly come to supplementary affidavit. This is
page 18.
Supplementary affidavit is comprehensive, more comprehensive.
And both
88.
So far as repetition is concerned, which I have replied with page 88, my lord.
Page 80, but he cannot reply, lordship. Nowadays, my lord, I address to chairman. It is to be by the chairman or its delegate, not by his lawyer. Nowadays, time will come when lordship direct the authority to adjudicate. The lawyer will adjudicate. No,
lawyer has replied.
Cannot be. He or his delegate. He or his delegate, not by the lawyer. Page 88, my one representation. And my lord, the other in the supplementary affidavit, page 18. 18.
Yes.
My lord, now I am answering about the section 9 application.
No, that is not in the ambit of this writ court.
Whether taken money or not, only one answer we are asking.
Court, that is altogether separate.
And whether that amount has been digested by them, my lord, and something remains.
Go to the court.
Money transfer is not in the ambit, cannot be an ambit within the 226. That is true, my lord. Your lordship.
They have issued show cause notice, the new information, let that show cause notice.
Yes, very good. It can be for consideration of the we will hand over the copy.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Supplementary affidavit filed on behalf of the petitioner is taken on record. Full stop. One partnership concern, namely Mitro Service Center within inverted comma.
May be permitted, my lord.
Yes. Consisting of two partners, being respondent number 6 and 7, are carrying business of as a dealer stroke licensee of HPCL. It is the case of the petitioner that the business was running in a financial crunch. Accordingly, one of the partner, namely Soma Das Mitro, approached the petitioner to relinquish his partnership business in the name of the petitioner. Full stop. In pursuance to such proposal, one memorandum of understanding was executed between the partners of between the yes, Soma Das Mitro. Between the partners and the petitioner, whereby the petitioner has paid an considerable amount of rupees 1,45,000, more than 1,45,000. It is a further case of the petitioner that the said partner, namely Soma Das Mitro, has also executed a power of attorney in favor of the petitioner to run the business on his behalf. The existing partners has placed an application for reconstitution of commission dealership with the authority concerned, stating every particulars to the fact that the partner, namely Soma Das Mitro, shall retire, and in his place the petitioner shall continue the business with 50% partnership. Subsequently, it appears to the petitioner that the proposal of reconstitution of partnership was turned down by the authority. Thus, the petitioner wrote a letter to the respondent number 7, through his learned advocate. Not respondent number 7, respondent number 6. In reply to his letter, learned advocate for the respondent number 6 has replied that due to receipt of a legal notice in connection with an application under section 9 of Arbitration and Conciliation Act 1996, it is not possible for her to give consent to reconstitution of the partnership. Full stop. Learned counsel for the petitioner submits that the partners of the business has acquired huge sum of money, but finally they have not allowed the petitioner to enter into the business. He submits that the authority concerned was hand in glove with the partners, hand in glove with the partners. Thus, he made a detailed representation with the authority for consider his proposal. Our proposal was not considered, but the authority concerned has replied his representation through has replied his representation through a letter of an advocate. He submits that though the authority was well aware about the huge transaction of money between the partnership firm and the petitioner, they have not allowed the petitioner to introduce in the said business by citing some flimsy grounds. So he prayed for necessary direction upon the authority. Learned counsel appearing on behalf of the respondent authority HPCL, HPCL submits that the transaction of money between the petitioner and one of the partner of the business was totally unaware. They have not placed the memorandum they have not placed the alleged memorandum of understanding or the power of attorney with the department. So it is not obligatory. No, stop. Mr. Chakraborty further argued that it is not obligatory for the authority to look into the private dispute between the partner and any third party. He submits that the agreement between the partnership firm and the authority concerned is still existing, and proposal for reconstitution was not further proceeded by the partners. Consequently, the same was closed. Mr. Chakraborty further submits that the authority has already taken the necessary steps for inquire the matter, and the said inquiry is yet to be concluded. Learned counsel appearing on behalf of the private respondent submits that the reconstitution proposal cannot be materialized due to the pendency of an litigation under section 9 of arbitration and conciliation. Full stop. Having heard the learned counsel for the parties, also considering the contention of the petitioner herein, it appears to me that the petitioner has heavily relied upon some document. Full stop. Next further. The petitioner has heavily relied upon a document wherein he urged that a huge amount of money was transacted between the partners and the petitioner, citing or make him greed to to transfer the license of partnership business. However, it appears that the transaction between the petitioner and one of the partner of the partnership firm is purely private in nature, by which the authority concerned within bracket HPCL cannot be made liable. However, it has to be looked into that the reputation of the concerned authority may not be used to malign the authority, or to collect money for showing that one person would be given the license. Full stop. At the to facilitate the petitioner, it appears to me justified that entire grievance of the petitioner may be relegated to the concerned authority, so that the authority concerned may take appropriate steps only for the purpose that no existing dealers can procure money showing the business and reputation of HPCL. Under the above circumstance, above observation, the instant petition is disposed of with a direction to the concerned authority to dispose of the representation of the petitioner placed in paragraph page 88 of the read petition, including the representation dated such and such, appearing in page 18. Representation dated, what is the date? Page 18. September 2024. 6th September 2024.
6th September 2024.
Appearing at page 18 of the supplementary affidavit, within 6 weeks from the date of passing of this order, after giving a reasonable opportunity of being heard to the petitioner as well as the private respondents. The decision of the authority shall be intimated to the petitioner within 2 weeks thereafter. Since no affidavits are exchanged, the allegation made in the writ petition shall be deemed to have been not admitted. Put some next para. I have not entered into this court has not entered into the merit of matter. The concerned authority or the appropriate authority shall take independent decision according to law without being influenced by any observation of this.
Grateful.
Next.
This matter, Miller, I am appearing for the petition.
I am appearing on behalf of the respondent number 6.
This is a case, Miller, for compassionate appointment, Miller, of fair price of Miller in place of deceased father.
May we file our affidavit?
On earlier occasion, Miller,
May we file our affidavit?
your lordship directed the respondents, including the private respondents, Miller, to file opposition, Miller. Till date, Miller, no opposition has been filed.
Filed today.
I am for appointment of 5 minutes. I am called minutes of filing my opposition minutes. Primarily minutes because there was a settlement talks going on minutes.
Time is necessary.
I have instructions minutes that they can come.
Amicable settlement will be made in the meeting. 3 weeks time.
Now, after filing the opposition by the state,
yes,
the settlement is going on.
I don't know settlement.
Brothers and sisters.
They were all opposing, and they record so in writing they have opposed. Yes. Now I don't know what they will do. But
I
am representing the sister.
The authority has taken a decision already.
Already, yes. That is challenged in this petition. And this ground,
that is under challenge in the writ petition.
Yes.
Then when they have taken already a decision, what you will do?
No.
This is incontroversial because already decision is taken. It has been rejected. The prayer for compassionate appointment has been rejected by after hearing them.
And Malad, on considering the objections raised by the other legal heirs of the deceased. Malad,
Now they have come with the proposal that there may be a
then
consensus.
they have to approach afresh.
But let it be disposed of, you will be given opportunity to approach afresh. If you are consensus.
In the meantime, my lord, the respondents are going to, my lord, declare the vacancy, my lord.
Yes, they would.
Has already been declared.
No,
That's
my
a
lord,
normal process.
in the meantime, my lord,
They
till such settlement, my lord, no vacancy will be declared, my lord.
That cannot be done.
That cannot be done.
That cannot be done. The decision has already been taken. They cannot be debarred to take a vacancy notification. This vacancy they had to do according to the law.
Yes. By operation of law, Malad, this has been.
Yes.
It is.
They have
It
to
is
proceed.
not at the
I
sweeping.
cannot restrain them.
It's
Till
the dispute
date, no
between the-
vacancy has been declared.
During
Now-
the
now, my
pendency
lord,
of the writ
Now, my
petition,
lord,
you have
private
not come.
respondents, my lord, are trying
Now
to
you are
settle the
coming with
matter.
the
I have
settlement.
no objection, my lord, to settle the matter, my lord. Then, my lord,
Malad, this matter cannot be settled. This statutory functionary has passed an order according to the statute. And this cannot be settled not by consent of the parties after this. So kindly have a look to my affidavit in opposition, page 3 once. One paragraph I just want to show. Kindly have a look to page 3.
এই মাত্র দিয়েছে।
Yes.
But the last paragraph, a perusal, a personal hearing was given at the chamber of subdivisional controller for so and so on. During personal hearing, the petitioner was informed that he was not to submit. He did not to submit a legal heirship certificate of Pran Govindo Chakraborty and also no objection of the legal heirs of the deceased. And in the meantime, 120 days has expired from the date of the said Pran Govindo Chakraborty, the original Bharati dealer. So as per WPBS Control Order 23rd, a APS vacancy proposal was initiated at the end of the government with a memo number 28th of June 2022. And as per proposal, a resultant vacancy was created, bearing number simultaneously processing all requirements of APS dealership under the vacancy going on in the office of the subdivisional controller.
Vacancy is going on, but till date, no vacancy has been declared.
This affidavit was affirmed.
Not been declared. Honestly, if there can be a no, my lord,
This is the 20th August 2024. This was the affirmation was made in the 30th of August 2024. Now, by the now subsequent development, if any, I have no idea.
Matter may be adjourned 3 weeks, my lord. In the meantime, settlement will be made.
Can give you a time to come after 3 weeks, but there will be no order. Let the state be proceed according to the law. There are no interim order, I think.
No,
There is no interim.
There are no interim.
Interim order is necessary at this stage, my lord. Till such settlement, my lord, no vacancy will
No,
be
no.
declared.
What settlement? Is statement from the bar.
Already they have taken
Otherwise,
decision. Now you are coming with settlement. Before decision, where are you? You are fighting each other. Now you have understand that what you have missed.
It was unfortunate.
You are fighting each other, and now
Written objections of each of the legal year is on record. Now, my lord, the consensus now, but the lordship kindly sees the written objections by the legal heirs.
they have filed written objections.
Yes, yes.
Now they are here for a consensus.
Brothers or sisters, I don't know. But then kindly see, look page 9 onwards, page 9, written objection by one brother, one son, then one daughter, then 11, one daughter.
Influence, my lord, the family member, my lord. Now,
Yes, now you take the lead. Okay. So what you want today? Please take down. Affidavit in opposition filed on behalf of the respondent is taken on record. Planet counsel appearing on the petitioner and private respondent seeks accommodation to file necessary petition for settlement.
Yes.
Let the matter go out of the list, parties are liberty to mention.
Yes.
we don't fix a date.
No.
সেটেলমেন্ট আমি তো বলছি তো
Next,
Liberty to mention.
liberty to mention milord
liberty to mention.
yes is a settlement milord no vacancy will be declared milord
No, there is no interim order. Yes, Mr. Bandyopadhyay.
I'm grateful milord.
Yeah. Maybe in opposition, I think like. So kindly go through in your this first order, passing the interim order. You will also recorded the entire facts in your lordship's order.
Without issuing any so cause notice.
They terminated. And that also, my lord, at the instructions of a second appellate authority.
Lordship, for this,
May I
your
just
lordship.
place your lordship the facts again, my lord?
Your lordship, I'm praying for not today, your lordship.
Why?
Sir,
You have filed the affidavit in opposition already.
your lordship, I have no knowledge about it. Your lordship, this matter has not come to the court, your lordship.
Mr. Chatterjee, where is Mr. Chatterjee?
Amritulal
Amritulal Chatterjee is appearing.
Yes.
But he was
Your
there
lordship.
in the morning.
No, I'm talking about Sonal Sinha, your lordship. Make it pass over, your lordship. He's in court.
Okay, tomorrow. Come on, tomorrow another same heading. Tomorrow. Affidavit and reply file on behalf of the writ petitioner is taken on record. Let the matter adjourn today. On the adjourn today. At the request of the state respondent. List the matter tomorrow under the same heading. Next.
There is a direction for filing everything.
Yes.
Milord, may I just indicate only one thing? Affidavit is not required in this matter. Only the point of law is involved. I will argue on the point of law.
Very good.
Lordship will decide the same.
Very good.
In that case, it will have to kindly take up next Monday. Because I was under impression they will prefer time for filing everything.
And only point involved in this matter is that just to indicate করে ছেড়ে দিচ্ছি. When the Milord, the statute has provided something, whether the writ court have the power to relax it or not. That is the moot question here. I am empowered with the special bench judgment of our court, several judgment of the Supreme Court, recent judgment of the Supreme Court. When the Milord, the statute is unambiguous.
I understand.
My lord.
Please take down.
দুটোই করছি.
Learned counsel. Mr. Suman Sengupta and Ms. Amrita Pajamouli appearing on behalf of the state authority submit that the instant matter can be disposed of on the point of law without filing any affidavit or report in the form of affidavit. Considering the submission, the matter be adjourned to release the matter on 10th. Another same heading.
10th Milord, kindly fix the time or at 2 p.m. or subject to convenience of your lordship.
New motion matter, it will appear fast.
Very well, Milord. Otherwise, the difficulty is that I will be stuck in the court number, Milord, 34.
Then come on 11th then.
No. Lordship kindly keeps it. Otherwise, I cannot, Milord, beg before like that.
Okay.
I just praying whether it is possible from this court to fix a matter on the fixed time.
Particular time. No, it is not necessary. I have already fixed.
Very well. Very well. I will come back, Milord. ঠিক আছে আমরা চলে আসবো.
Yes, next.
Your Lordship, I appear on behalf of the state in this matter, Your Lordship. There was a direction to file affidavit. Your Lordship kindly grants a week's time to file the same. It's ready, only it is due to be affirmed. Your Lordship, it shall be affirmed in due course of this week, Your Lordship. Kindly grants us a 1 week's time, Your Lordship.
Whether interim order is there?
No, Your Lordship. There was no scope for any interim order.
An accommodation is sought for on behalf of the state respondent. Let the matter be urgent today. List the matter on 10th under the same heading. The state respondent.
Your Lordship, the reply will be filed by my learned friend, perhaps. So that may also be extended.
Okay. The state respondent is at liberty to file the report in the form of affidavit within the urgent.
Your Lordship, it was an affidavit in opposition.
Affidavit in opposition within the urgent date by supplying an advance copy to the petitioner.
Gratefully.
Kindly considerable. It was not opposition. They were supposed to file the report in the form of an affidavit.
If there is a report, then it will
Then
be
report. If it's an
If the affidavit, then it will be affidavit.
in any event, it is an affidavit.
Actually, on last occasion, my lord had been pleased to pass an order directing them to file the report in the
form of. Okay, this will be report in the form of affidavit.
Exception to that.
Advance copy.
Advance copy.
You receive the advance copy. Thereafter, I will take up them on the next week.
My lord is fixing on
10th. 10th.
10th, within 10th, we will file it. Your Lordship, they might need some time to file the
No, you file it first. Thereafter, I will take up the matter.
As you know.
Gratefully.
Next.
Well, item 21, I am for the petitioner. We have got the opposition. We need to
But I
file-
am for the respondent.
We need to
Kalyan.
try praying for 1 week time to file the reply.
Reply.
Yes, my lord.
Let the opposition be kept with the record. My landed sister has handed over.
Okay, okay. Affidavit in opposition file on behalf of the state respondents is taken on record. Petitioner 6. Accommodation to file a reply against the affidavit filed by the state respondent. Let the reply be filed within a week. List the matter on 12th of March. Under the same-
Grateful, Lordship.
Grateful, my lord.
Next.
I for the petitioner, my lord. Let I beg to appear in this matter. Ma'am, the learned advocate, Mr. Dilip Kumar Maiti, is appearing in 18 number court. Kindly pass over the matter sometime.
This is a new motion matter. Passover.
Pass over, yes, pass over.
Not today. Tomorrow. Next. 23, not today. 10th of March. 10th of March.
Mr. Shishanu Bandyopadhyay has been engaged on behalf of state in this matter. The point of maintainability was taken on the last occasion. And pursuant to the point of maintainability being taken by us, my lord, the petitioner stated that they will file an affidavit on the point of maintainability. No such affidavit, my lord, has yet been received. This is an writ petition challenging the order of fine. After order of fine, imposition of fine to a delinquent dealer. So, my lord, without preferring an appeal before the district controller, my lord, under the statutory control order, they have preferred this writ petition. So, my lord, we had taken the point of alternate availability of alternate remedy. My lord, that was not argued by them on the last occasion. No affidavit is yet received, my lord.
None appears on behalf of the petitioner. No affidavit is placed by the petitioner against the point of maintainability raised by the state respondent.
কোনটা হচ্ছে
None appears করেছো? Let the matter be go out of the list. Parties are liberty to remain.
Out of list.
Next.
My lord, I am for the petitioner. My senior engaged another.
Is the case, my lord. People are having two persons clubbing together filed a petition. Both are applicants. The pair is that alternatively any of them will get license. I don't know how this is maintainable. Kindly take up the petition just for you. Instance,
I'm praying for short work.
your first state. Just one paragraph. Kindly see how it is.
What is the, who is the petitioner here? You are for the petitioner.
Kindly see the first page of the writ petition. First page. First page. Kindly see petitioners. Pritilata Sarkar, Rakib Sheikh. Have you also got my lord? The first item.
Pritilata Sarkar and Rakib Sheikh are the
Kindly
petitioners.
come to paragraph page 5. Paragraph 5 and 6. If it states that petition number 1 had duly applied for appointment as fair price shop dealer, a copy of the received copy. If it states that the petition number 1 had all eligible criteria for so and so, then kindly come to page 14, page 7. Page 7, paragraph 14 and 15. Petition number 2 is also eligible, he also applied for. Two petitioners, both have applied for, and kindly come to prayer portion, page 14.
Both of them filed the same application.
And kindly come to prayer. See, what is the prayer? Prayer A. Edit in the nature of mandamus do issue calling upon the respondent authorities appoint the petitioners or any of them. So some restriction.
Oh,
Yes. And pair B, kindly see methodology to be intimated to them. And so far I am concerned, I have already been selected. Running to website. I am running my business. There is no dispute. Everything completed.
Whether they have served upon the state authority?
Yes, state is present.
Okay, you
It
are
is also
appearing
present.
today. On the earlier occasion, they have not served. That's why direction was there to serve upon you. So where is the petitioner?
Why not engage one another? Kindly not today.
It takes it up next week. Some difficulty tomorrow and
Next week, Monday. On the prayer of the petitioner, the matter be adjourned to release the matter on 10th under the same head.
No allegation against. I have been selected. I am running.
Okay.
Great. Not to
Pilot,
You are in the next matter, item number.
may I be permitted to mention a matter, item number 24.
Very good.
24, I have already passed the order.
Pilot, praying, apology.
What apology? 24 is out of the list. It is go out of the list. It was go out of the list.
Pilot,
You mention it Monday. Monday or Wednesday.
On the 26th, I am appearing before state respondent, my lord. On last occasion, your lordship was pleased to direct us to prepare a report. And a report was prepared and it was served upon my learned friend, the petitioner. But unfortunately, my lord, I lost the original affidavit, my lord. Kindly give us some time, my lord. I have to test out, my lord. It is served already.
Have you served upon them?
Huh?
Have you served upon
Yes,
them?
yes. Mr. Ramesh Dhara is appearing for the petitioner. He was just here.
So what you want today?
My lord, kindly take it up Monday, my lord.
Next Monday?
Yes, my lord, next Monday. It is somehow misplaced. I will find out, my lord. Kindly.
An accommodation is sought for on behalf of the state respondent. Let the matter be adjourned for a week.
And my lord, no reply has yet been served, my lord.
Okay, very well. I have just adjourned the matter.
Yes, sir.
Next.
The matter will take up next Monday, my lord.
Next week.
Okay.
27, I'm for the petition. But last occasion, your lordship was pleased to direct the state authorities to file report. But
No report.
no report. No one is appearing.
Who is appearing for the state authority?
But Amritlal,
Miss Sinha is appearing.
yes.
None appears on behalf of the state respondent. Let the matter be adjourned today. The filing of report in the form of affidavit is extended for 2 weekends. Reply, if any, by the petitioner within 1 week thereafter. Let the matter appear in the list on 25th of March under the same heading. Yes, next.
I'm for the petitioner. Page 28.
Yes.
Vacancy decline notice dated 10th of January 2022. Location Hridaypur, yes, Chapra district note. 28.
Training. Creation of vacancy under 2013.
Yes.
But page 31 is the my application. Has been received on 17th March. Acha. 17th. Within time, I have applied for. Next page, page 32 is my duly filled in prescribed application.
Yes.
Serial number 3, name of the applicant, Ajhar Sardar, petitioner before your lordship. Then kindly come to serial number 14. Educational qualification, higher secondary. Mark it, my lord. Next page. Location of the godown, serial number 30. Full address of the Shopcom godown, village, Bedberia, Hridaypur, Chapra, central location, central point of the location. Then, my lord, dimension of the godown. Length, breadth, height, length, breadth, 902 square feet. Character of the land, Hita, size of the Shopcom godown, 290. It comes around 1192, 902 plus 290. Serial number 36, dimension shed for queue of beneficiaries, 200 square feet. Whether godown is accessible 10-ton truck, yes. Page 34, serial number 41C, extent of ownership, absolute share, absolute owner. Page 34, well. Then kindly turn to page 39. Bank balance.
Yes.
Kindly come to page 40. Page 40.
Account details.
Yes. Kindly come to page 41, man. Dated 17th March. I have shown to your lordship date of application 17th March at page 31. From second column, page 41, 17th March 2020, 4,82,820. And Then page 43. The photograph of my shop come go down. 43 is the go down. Next page 47, 44 is my shop come go down, shop room. All photographs I have annexed. Then kindly turn to page 47. These are all prior to inquiry. And the date of application, this all infrastructure was there. Then page 47, I have been intimated that an inquiry will be conducted. At page 12 April 2022, this is the notice.
Yes.
So the inquiry has been conducted. Then kindly turn to page 49. I have been called for by the district level fair price shop selection committee. This is the notice of 21st of June 2022. Kindly mark the date 21st June 2022. I have been intimated, third line left hand side, 29th of June 2022, inquiry will be conducted.
Yes.
Inquiry has been conducted on that day in respect of all shop come go down of all the candidates. Now your lordship kindly turn the page, 19th October 2022. Another notice, that is after 4 months. My specific case is that the shop come go down of the private respondent was not completed at the time of first inquiry, and an officer is involved in this matter have categorically stated at his instance influence second inquiry has been conducted. There is no such provision. Kindly come to my lord, page my lord 50. 2 interviews. First interview 29 June, second interview 7th of November. Third line left hand side. After 4 months.
Yes.
My specific case in my writ petition, during this period, a fresh inquiry has been conducted. All the shop come go around of all the applicants. I have categorically stated my lord in my writ petition, I will show to your lordship. Then the second hearing has been provided. I have not been intimated anything so far the second inquiry has been conducted. Only on the date of inquiry, I found that some persons came here there and took measurement. So for the private respondent is concerned, my specific case with intimation that inquiry has been conducted only to show that his shop come go down has been completed. Now kindly turn to my lord, page 51. After that second hearing, my application has been rejected.
Yes.
Now license has been granted to the private respondent at page 52. Kindly see my lord. This is the first time I am seeing a document which says not 190, not 201, not 390 square foot, not 401. Kindly take note of page 52. Shaheen Sharif Maslana Khalsana is the private respondent who got the license. Left hand side, kindly see my lord, table. Shop and go down building details. Shop and cover different chambers. Yes, different chamber. Shop and go down is single chamber. No. First criteria. 52.
What are you reading?
Page 52. The license granted to the private respondent. I am showing your lordship the last but one table. Left hand side, shop come go down building details.
Yes.
Shop and go down in different chamber? Yes. Not a single compartment. Shop and go down is single chamber? No. Size of the compartment, single chamber, size of the shop. Kindly see 200 square feet, 400 square foot and 200 square foot. Neither 399 nor 401. Nor 199 nor 201. 400 square foot, 200 square foot. My specific case in my writ petition, neither the shop come go down, nor the shop go down, nor the shop room fulfills the eligibility criteria. Both are shorter in size. Second inquiry I have shown to your lordship. This license has been granted. Date of issue kindly see bottom 11th December 2024.
Yes.
The second hearing was conducted 7th November. License has been granted 11th December. Now, Your Lordship, kindly turn to my representation at page 58. Immediately after finding that he is running the dealership, I lodged a complaint with the Secretary, Director, District Controller, Subdivisional Controller on 23rd of December 2024. Subject complaint. Your Lordship need not go through the entire document. Kindly turn to page 60.
Yes.
I'm reading from paragraph 2, page 60. That after such inquiry, the inquiring personnel forwarded the entire file along with their favorable comments for grant of fair price shop license in my favor against the subject vacancy to the Subdivisional Controller Food and Supplies Krishnagor and the Subdivisional Controller Food and Supplies Krishnagor Sodor. After scrutinizing all the papers and documents, including the report of the respective candidates, accordingly, Subdivisional Controller Krishnagor Sodor forwarded my name with the specific comments for grant of fair price shop license against the subject vacancy to the District Controller Food and Supplies, and the District Controller Food and Supplies sent the said file to the District Level Fair Price Shop Selection Committee. That thereafter the District Controller Food and Supplies memo dated so also instructed me to appear before the District Level Fair Price Shop Selection Committee on 29th of June 2022. That as per instruction contained in the memo dated 21st of June 2022, I remained present on the scheduled date, time and venue and participated in the interview, and in the interview itself, I had been declared as most suitable candidate. That after interview, entire file was forwarded to the Director, District Distribution, Procurement and Supply for obtaining approval for grant of fair price shop license in my favor. That instead of granting fair price shop license in my favor, since other applicant, namely Shahin Sharif Halsana, kindly take note of this paragraph, who is cousin brother of Lothipuddin Sheikh, Deputy Director Law, District Distribution, Procurement and Supply, at the instance of the higher authority, another inquiry had been conducted. However, before conducting such inquiry, neither any intimation had been given nor any communication had been made, and during course of inquiry, the inquiring personnel put pressure upon me for endorsing my signature in a blank paper, and due to such pressure, I had been compelled to put my signature forcefully in the said document. That after conducting second inquiry, District Controller Food and Supplies Nodia, only to IOS, by memo dated so instructed me to appear before the District Level Fair Price Shop Selection Committee on so and so for personal interview for giving undue advantage to the said Shahin so and so, the cousin brother of Lothipuddin Sheikh, Deputy Director. That as per the instruction contained in the memo dated so and so, I was remained present at the scheduled date, time and venue as per instruction of the District Controller so and so. That when I was waiting for the fair price shop license against the vacancy so and so, since I am the most suitable candidate in all respect, all on a sudden with an utter shock and surprise, I came to learn from the official website of the Food and Supplies Department that my application has been rejected. Kindly turn, my lord. Skip over the next paragraph. Kindly turn to the last but one paragraph. That I also came to learn that said selected candidate, namely Shahin Sharif Halsana, son of Abdul Khalek Halsana, being the cousin brother of Lothipuddin Sheikh, Deputy Director Law, District Distribution, Procurement and Supply, has become the blue-eyed candidate of the Food and Supplies Department, and by way of arbitrary, malafide, illegal manner, the said AP shop license has been granted in favor of said Shahin Sharif Halsana, son of Abdul Khalif Halsana. That I also came to learn that the said selected candidate, namely so-and-so, son of so-and-so, is the relative cousin brother of one so-and-so, fair post, Deputy Director Law, so-and-so, Government of West Bengal, according to the influence of the person, post of so-and-so, Shahin so-and-so. Then, my lord, page 61 is that. Next complaint, my lord, page 62. So, my lord, this is my case. Since he has got the license, today possibly I may not pay for any injunction order. I want a affidavit in this matter by a higher authority.
Higher authority or not, that's a different thing altogether.
No, definitely, my lord.
He may place his case at a high pedestal, but my lord, merely because someone is deputy director, something relative, my lord, we'll have to go by the control order. Who is barred, who is not barred.
Yes, yes.
My lord,
Please take down. What is the
I'm not arguing because
on next side,
long back, my lord, the license has been given.
Yes, sir.
please take down.
In fact, my lord, Mr. Shahrai moved the matter for a stay of this vacancy on the ground of 2013 control order.
Your lordship has
itself, no, license has already been issued.
Already
Yes.
issued. But existing dealer already challenged the sanction notice moved by Mr. Tara.
Very, forget it about it. After hearing the learned counsel for the parties, it appears that this matter cannot be disposed of without giving the appropriate opportunity to the respondent to file affidavits in opposition. Let the affidavit in opposition by the state respondents and the private respondent be used within 4 weeks.
4 weeks. 3 weeks.
4 weeks and a reply within 2 weeks. Reply by the petitioner within 2 weeks thereafter. Let the matter appear in the list on 10th of April.
Fine.
10th, right? It would be 9th of April. 9th of April.
May I say one
Under
one
the
thing,
same
my
heading.
lord? That the affidavit may be filed by the director. Because I have lodged a complaint against the deputy director. They will not be prejudiced. Director is a party.
Director has to come for filing the affidavit, but the concerned
Will
person
deputy
who has-
person.
the concerned person has filed the.
My lord, he is the subordinate officer. Kindly take note of.
No, whatever may be, they have to place the reports and everything, all documents.
Authorized by everybody.
The affidavit report will be same.
Lordship knows by learned
Authorized by
counsel.
every other person.
Yeah. Complaint against the deputy director. A subdivisional complaint has any power to say no.
And
You
the
have not been.
petitioner has not been
No,
made
you have
party.
already stated the name of the particular person.
And the
That has
petitioner
to be
not
taken
been
up
made
at the
party,
time
my
of
lord.
hearing.
He has not been made party by name.
Whatever may be, some designation has been mentioned in the
Let them file.
complaint. Let them file what they file. Thereafter, I will be- Next.
29.
In item number 29, I beg to appear for the petition. The petitioner have been given in accordance with the license to carry out the fuel station
Have you,
in a
sir?
state highway. Yes.
I am opposing one.
No, I wanted to know whether you have served or not. Okay. Now to the car. Agata. Yes, what is the matter?
It's not
The matter relates to that. The matter relates to that, my lord. The petitioners before your lordships are the licensee of the fuel station in a state highway, and in accordance with law, with payment of all the fees and all requisite. And subsequently, within 1,000 meter of the fuel station, the same company has been given license to another.
You have mute
Very
your.
audible, my lord.
Yes, you have mute
Okay.
your mic. Now it is unmuted. Yes,
Okay.
submit.
Yes, my lord. There are some restrictions on the use of two successive fuel stations within 1,000 meters. My lord, kindly take a look at page number 40 of my writ petition.
Page number 40.
40. The guidelines issued by the Central Highway Department Ministry is applicable also to the states. It is starting at page number 38, that is the Government of India directives to all the state governments. And my issue is at page number 40. My lord, 6.2.1, that is the number.
Yes.
In non-urban or rural areas, Roman 2, divided carriageway with no gap in median at its location or stretch, including deceleration and acceleration lanes, there must be 1000 meter difference between two petrol pumps. My issue is that the subsequent petrol pumps in the open category that has been allotted in the name of the private respondent within 1000 meters, and that is prohibited. I have urged my point at page number 4, paragraph number 6 and 7 of the writ petition.
Now, where from you came to know that they are going to give the license?
My lord,
within,
that is at page number. Yes.
Within 1 kilometer?
My lord, kindly see page number 69.
Page number 69.
And that open category has been primarily allotted in the name of the private respondent.
Where is your license?
My at page number 22 running, starting at page number 22, that is the agreement that was given to me.
Yes.
Without without considering this restriction given by the Ministry of Highways, this new license has been given.
What is the location of your petrol pump?
Location that is at page number 3, paragraph number 2. 5 km from Kolachhara, post office Arambagh.
What does it mean? Within 5 kilometer means?
That means the Kolachhara is the space. From Kolachhara, there is the main area, Kolachhara. That is within 5 kilometer of Kolachhara under post office Arambagh.
So how
National
ascertain now prima facie that any vacancy is there within 1 kilometer? You have to prima facie.
Yes, under page number 69, no specific specific. That is the only given Chonditola 2 BDO office, Bank of India. That is within one SH15. That is within the 1 kilometer gap of my petrol pump.
No, that is your only contention. Where is your petrol pump? In which spot your petrol pump is?
Is that that is given at my agreement also, my lord?
In agreement, I have seen nothing regarding the location of your pump. Where is the location of your pump?
Well, this particular address is there only SH15 Post Office Arambagh District Hubli Kolachhora. Well, the private the petroleum company may identify also specifically because this is only given to us.
So you have to specify where is your petrol pump, what is the plot number, where it is located, in which spot, and the spot of the private respondent in favor of whom the
Okay,
license
my lord,
is.
then I have to file one supplementary affidavit, my lord, but because I have to give, my lord, later that leave be given, my lord.
Privacy you have to satisfy, otherwise I cannot proceed.
Yes, my lord, I will give the revenue records also regarding the spot of the petrol pump. My lord, kindly give one leave, my lord, to
Maintainable one.
Not maintainable.
I mean, indicate one of the agreement that my learned friend is trying to indicate, his petrol pump has been set up on a state highway.
State highway.
The guideline he's taking shelter of is a national highway.
Yes, guideline he submit there is a national highways guideline.
National highway guidelines are not applicable in case of state highways. Additionally, the guideline which my learned friend has annexed to the writ petition, that has been repealed.
Repealed.
There is a new guideline of 2020 which is being followed. And if a petrol pump is being set up on a national highway, only the permission of the national highway authorities have to be taken. That is purely not applicable in state highways. I'll demonstrate from the document, my lord, annexed by my learned friend only. If your lordship comes to his letter of appointment at page 13.
Yes.
But subject.
Page 30.
1-3.
Page 1-3.
1. But the letter of appointment of the petitioner.
Yes.
Proposed MS retail outlet dealership at location within 5 km from such and such on SH15.
State highway.
On state highway. So now today he can't go and say that yes, the national highway guidelines are being infringed. Kindly comes to the next paragraph, my lord. Next to next paragraph. We have pleasure in offering you MSHSD dealership in respect of our retail outlet location within such and such post office towards Arambagh on SH15 district Hooghly in the name of such and such, such and such. But I'll hand over a copy of the guideline of the National Highway Authorities
2020.
2020. In other matters, I had the occasion to place you before your lordship, my lord. But in all these cases, in every single page, my lord, it's indicative that any petrol pump, if it's been set up or proposed to be set up on a national highway guidelines will be applicable. I will, to cut short the matter, I'll take your lordship directly to page 22 of the notification. This is annexure 2,
yes.
A checklist. Kindly sees what are the provisions that are to be complied with for setting up a checklist for getting approval for installation of new fuel station along national highway such and such. Kindly sees what are the requirements required. National highway number, district and state, location, then Roman 5, side of NH, Roman 6, name of National Highway Authority, Roman 7, highway administration process, name of oil company such and such, such and such, such and such. If it's a guideline. But now if your lordship comes to the guideline, my lord,
yes.
I take your lordships directly at page 13. Norms for location, layout, and access to fuel stations along national highway. The relevant clause is clause 1.2.
Okay.
Well, the first line is perhaps not important in our matter. Where national highway passes through town such and such, the state shall be, this is not, 2.1. So norms for existing service or street road such and such. However, permission for retail outlet proposed on existing service roads such and such needs to be obtained from the highway administration to require all other requirements such and such, such and such. Well, these are all requirements which are to be fulfilled in the event a petrol pump is supposed to be set up on a highway. Purely not applicable in the case of my learned friend.
Okay, we have got the time. So,
even here and pass order.
My lord, may I submit one thing? If national highway norms is not applicable in the state highways, what my learned senior friend is submitting, what he is also inviting your lordship's attention on the guidelines of national highways. He is not also relying on any other norm which is purely applicable in state highways. My lord, 2020, the norms that has been published, that is also given to the state governments as a guideline for submitting the petrol pumps in all states, because these guidelines have been referred to all the chief secretaries and all the state governments to implement the same in everywhere in all states.
Okay, come on after 2.
And let me file one supplementary affidavit. I will
Supplementary. Point of maintainability has been raised. You have to answer it. Come on at 2.
My lord, your lordship, my lord, I believe so, after 2, your lordship are taking up motion matter. My lord,
I can take up the motion matters.
2 p.m. there are so many fixed matter, madam.
But
5
after
questions.
the fixed matter, lordship will take it up.
3 matters, consecutive 3 matters are there. I am hearing that matter.
Yes,
I have concluded the hearing.
Another 2
After another 2 matters.
Another 2 matters are
Yes,
there.
my lord. That's why, my lord, I am just submitting your.
After that, lordship can take up my matter.
My lord, your lordship.
But at any time, my lord, that
Yeah,
may be given.
No, today I will dispose of this matter.
Well, I don't know, 31 and 32 are vacancy matter. Let these appear tomorrow as I mentioned matter.
31 and 32.
My lord.
53
31 and 32. 30, 31 and 32.
and 53 and 54 also.
53 and 54. 53 and 54. Mention matter.
Right.
Okay.
So after 2 p.m., lordship will take up
this matter.
after the 2 p.m. fixed
Thereafter,
matter.
I will.
Very good.
Great.
के बाद पूछ रहे थे ना, डबल बात कर रहे थे ना, क्या दरकार है
Before your lordship takes up on regular matters,
Yes.
Item number 6. Your lordship was pleased to pass an order regarding the maintainability of the writ petition, but we have assailed your lordship's order before the honorable division bench, and the matter is likely to be appearing tomorrow.
Okay.
So let the matter may be adjourned for some time so that matter. Item number 6. Yes.
Okay.
I'm for the
After 2 weeks it will appear after 2 weeks.
Yeah.
Item number 6 after 2 weeks. Call the list. Call the list. রাখুন এটা পরে এটা পাস প্যারাগ্রাফ পরে whether private respondent have concluded.
They came only two occasions. Private argument of I have not taken any note.
No. Private respondent. They have started their twice argument 2 days. For 2 days. They concluded. Okay. Who is appearing for the private respondent? Today no. No, today no one is appearing. Sami Akhtar is appearing. Very well. If they have concluded, so today we are for response, for reply. Yes. This one. Antora Gargi and Nomita. Yes.
My lord, I mean Antora, my lord, I addressed your lordship, my lord, in the first matter.
In the first matter.
Yes. Now, my lord, by one of the contention was, my lord, I am proceeding on the basis, my lord, they have responded. One of my contention was, my lord, that the land offered by the private respondent was or is not fit for either, my lord, the setting up a godown or a showroom. In support of that, my lord, I had showed, my lord, my pleadings as well as photographs, as well as, my lord, these certificates given by the authorities, which says that this is a water body where, my lord, cultivation or pisciculture is being carried on. My lord, if your lordship is pleased to come once, my lord, to my petition.
Item number 1. One, Antora. Yes.
My lord, if your lordship is pleased to come to, my lord, the documents, my lord, page 49 onwards, 49, 50 and 55. First one, my lord, the document at page 49 I have relied on. আপনার আবেদনের পরিপ্রেক্ষিতে জানানো যাইতেছে যে মৌজা উচিলদহ জেল নাম্বার such and such জমি দুটির শ্রেণী যদিও বিলান কিন্তু দীর্ঘ 30 বছর যাবৎ উক্ত জমির শ্রেণী ব্যবহারিক ক্ষেত্রে পরিবর্তন হইয়া
মৎস্য ভেড়ি হিসেবে ব্যবহৃত হইয়া আসিতেছে, এই জমিটিতে যানবাহন চলাচলের যোগ্য কোনো রাস্তা নাই, এমনকি মানুষ চলাচলেরও কোনো রাস্তা নেই। This is the first one. The second one, my lord, I have relied on is at page 50.
Yes.
On the left hand side bottom, lordship will find উক্ত দাগটি মৎস্য ভেড়ি হিসেবে ব্যবহৃত হইয়া আসিতেছে, উক্ত জমিতে যানবাহন চলাচলের যোগ্য কোনো রাস্তা নাই। And kindly come to page 55 once.
Photograph.
Photograph. Now, my lord, there is no denial of these facts. Now, it has been sought to be contended by my lord IOCL that no,
It's a Bilan land,
it's a bilan.
agricultural
And
land and
it can be-
convertible.
It can be, my lord, converted. Now, in support of that, my lord, a decision has been relied on, my lord, of this honorable court, my lord, a decision, my lord, of Justice Saraf. My lord, kindly come to that, my lord, the judgment dated 5th September 2019 in WP number 14338.
Yes.
Now, before that, my lord, before going into that, my lord, may I also show your lordship a document, my lord, annexed to, my lord, the Gargi Mundal's application. My lord, may I read it out? This is a certificate given by the BLLR. It says, this is to certify that as per field inquiry report submitted by RI concerned, there is situated pond, no road running through plot number 1612 of Mouja Uchibdoho, jail number 96, and plot number 1620 of Mouja Artpukur, jail number 153. The said plots are presently used as brackish water fishery. The classification of the said plots are recorded as B by the BLN. Now kindly come to the order, my lord, of Justice Saraf, my lord. I shall show you or try to show your lordship why. My lord, this order, my lord, does not apply in the facts of the case. But kindly come to paragraph 7 directly, my lord, where submission of Mr. Chakraborty is recorded. My lord, kindly come to paragraph 7 about, my lord, 6, 7, 8 lines from the bottom.
Yes.
Sentence starting with regard to the second contention.
Yes.
With regard to the second contention of the writ petitioner, on suitability, he submitted that classification of the land in the land revenue record is not considered as one of the eligibility criteria for evaluation of the offered land. He further submitted that the respondent corporation, under its own policy guidelines, conduct suitability test of the offered land on the basis of parameters fixed in the guidelines. In case where the land is not a Vastu land, evaluation of the land is done, and if required, the applicant is directed to convert the said classification of land before the construction and commissioning of retail outlet. Now, pausing here for a moment, this case has not been made out by IOCL in its affidavit in opposition. In our case, number 1. Now, kindly continue, my lord, paragraph 8. He further submitted that classification of jol only indicates that the land is an agricultural land where crops are grown and is distinct from pukur, that is pond and or any water body. Now, my lord, here, my lord, though it is Bilan, my lord, written, but photograph would show and the certificates would show that, my lord, it is being used as, my lord, for pisciculture, my lord, a fishery. He submitted that the restriction on conversion of water bodies does not apply to jol land. Now kindly come to paragraph 11. At the very outset, I have to state with regard to jurisdiction of this court that the writ court under Article 226 of the Constitution does not examine every decision order and if the court is as if the court is sitting in appeal. It is the mechanism and process that has been followed by the authorities corporation that is looked into. Kindly take note. It is the mechanism and process that has been followed by the authorities corporation that is looked into. And if the same is not found to be perverse and or arbitrary, there is normally no requirement to interfere in the said process. It is to be further kept in mind that in a writ proceeding challenging contracts given it by a public corporation, the window for interference is minimal and the writ court could only interfere when it finds a palpable illegality having been committed by the corporation with reference to the statute, rules, guidelines. Here, my lord, there is a complete deviation from the guidelines. I have shown your lordships, my lord, I shall come back to that. The, my lord, family did not include or does not include in the guidelines, the definition of family does not include, my lord, father-in-law. That was ignored. So far as, my lord, the field verification is concerned, my lord, there is nothing on record. They were supposed to carry on field verification. There is nothing on record. They do not say that in course of field verification, it was found that it was not a water body. Or there is a road in between. No, that is not forthcoming. The recent decision of the apex court in Caratel Infotech, but I shall come to that. They have cited this also. Now kindly come to paragraph 12. Coming to the facts in the present case, I have examined in great detail the deeds and purchase produced before me. It is clear from the same that the respondent number 4 had provided to the Indian Oil Corporation 24 decimals of land that was more than the requirement under the terms and conditions. With regard to the fact that a portion of this land was classified in the land record as jol, my lord, that is not, my lord, the case here. The entire thing is, my lord, Bilan and, my lord, the entire land has been shown, my lord, as can be seen to be, my lord, a water body. I am of the view that such a classification does not make the land unsuitable for the purpose. It is known fact that land lying in the rural and panchayat areas would be used for cultivation. And it is only when a person decides to carry out a commercial venture does he apply for conversion of the said land. Unless the land is designated as pukur water body, there is normally no impediment in such a conversion. IOCL that grants contract to hundreds of dealers, etc. Next, the contention of IOCL is that they themselves assess and evaluate the land. And if they find that the said land is such that could normally be converted, then such a land would fit with the criteria of suitable land. Again, my lord, this case has not been made. Yes, there is, my lord, nothing on record to show, my lord, that this assessment and evaluation has been made. No statement, no document.
Now, this case has to be made out in the affidavit. This case has never been made out in the. Neither by IOCL nor by the private.
Yes.
Now, it has been next submitted before your lordship that the authority will look into the records of right of the land and not the mode of use of the land. Now, my lord, this is, if I may ask myself the question, then why the field verification? Then they say application was made through online. Very well, yes. And on scrutiny, eligible candidates are only permitted to participate in the draw of the lots. Till then, my lord, I have no difficulty. Then comes the next step, which is field verification. Field verification, my lord, could not have passed. In any event, even during in course of drawing of lots, my lord, the lands were not within the jurisdiction. And that is why their application was rejected.
Yes.
Now, next, it has been submitted that it is the duty of the selected candidate to convert the land. Nothing has been done. Next, my lord, it has been submitted that, my lord, the submission in regard to the family unit, it is a mistake in the application. My lord, with respect, whose case is this? IOCL has not made out this case. The private respondent has not made out this case. It cannot be anybody's case that it is a mistake. Your lordship, I am not, my lord, wasting your lordship's time. Your lordship has seen family members or family unit even includes, my lord, stepson, stepdaughter. But for some reason or other, father-in-law, mother-in-law is excluded.
No, it was argued that the father-in-law is included.
Sorry, my lord?
Father-in-law is included. It is argued.
No, no, no. I have shown your lordship, my lord. Kindly come to, my lord, kindly come to the brochure.
Yes.
My lord, which is, my lord, affidavit in opposition of IOCL. My lord, kindly give me a minute's time, my lord. I shall find out the relevant affidavit in opposition of IOCL. Lordship will kindly come to kindly give me a minute.
Page 30.
Page 30, yes, I am obliged. The applicant kindly come to page 30, my lord, ownership or own for go down.
B.
B, registered lease deed having minimum 15
Yes.
years of valid lease period commencing on any day, etc. Then,
Yes.
additionally, applicants having registered lease deed commencing on any date prior to the date of advertisement will also be considered, provided the lease is valid for a minimum period of 15 years from the date of advertisement. Then, the applicant should have ownership as defined under the terms of own above in the name of applicant, member of family unit, as defined in multiple dealership, distributorship, norm of eligibility criteria, parents, including stepfather, stepmother.
Yes.
Grandparents, both maternal and paternal, brother, sister, including stepbrother and stepsister, son, daughter, including stepson, stepdaughter, son-in-law, daughter-in-law of the applicant, not the father-in-law.
son-in-law, daughter-in-law,
daughter-in-law of the applicant
or the spouse.
in case of married applicant as on the last date of submission of the application.
So it is argued that son-in-law, daughter-in-law, thereafter semicolon of the applicant or the spouse. Or the spouse includes the father of spouse, parents of the child. This is argued.
Has my lord IOCL made out that case? If I may ask myself the question in the affidavit. No. And kindly read it, my lord. It's entirely for your lordship to decide. Of the applicant, son-in-law, daughter-in-law of the applicant, or the spouse in case of married applicant. So spouse is kept differently, that yes, if it belongs to the spouse, he is, my lord, a member of the family unit.
No, it is argued that
it does not say
what they argued. That I am stating it. It is said that the both maternal, paternal, grandfather, or the son-in-law, or including stepbrother, stepson, sister, everything includes the applicant as well as his spouse. That means spouse brother, spouse sister, spouse son, spouse brother-in-law, everything would be applicable under that term.
So, my lord, the spouse is not included otherwise.
In case of married applicant, the spouse's father had also been taken to be considered to be the family. This is the argument they have.
May I understand this? So, in case it belongs to the spouse, is he a member of the family unit? No. Kindly, may I read it once again? Family unit as defined, dealership, etc. includes stepfather, stepmother, grandparents, both maternal and paternal.
Yes.
Sorry, parents, including stepfather, stepmother, grandfather, both maternal and paternal, brother, sister, including stepbrother and stepsister, son, daughter, including stepson, stepdaughter, son-in-law, daughter-in-law of the applicant
or the spouse.
So, my lord, it qualifies this, my lord, the earlier things qualify the spouse, not the spouse himself. It will, my lord, if I may again read it, my lord, lordship will find, my lord, it does not make sense. The applicant, his or her family unit may include, my lord, his or her stepfather, stepmother.
Yes.
Not the spouse's stepfather or stepmother.
Or spouse's parents, or the stepfather, stepmother, like that.
Or, my lord, include stepfather, stepmother, grandparents, both maternal and paternal, brother, sister, including stepbrother and stepsister.
Yes.
That means, my lord, they want to mean, my lord, it can be, my lord, spouses, stepbrother and stepsister.
Yes. All indicates the applicant as well as the spouse.
Then, my lord, with respect again, my lord, it's entirely for your lordship to decide. Then possibly the wording ought to have been of the applicant or of the spouse, not the spouse. Or of the spouse.
Yes.
My lord, also kindly in this context, also kindly consider you at the top. This was also placed by me. Family unit for multiple dealership distributorship norms means the following. In case of married person applicant, family unit will consist of individual concerned, his or her spouse, and their unmarried sons and daughters. Nothing further. And then it goes on, my lord, the additions for ownership.
Ownership.
Now, if, my lord, in the subsequent clause, if, my lord, or, my lord, what has been sought to be said, of the spouse means, my lord, or of the spouse, of is missing. And the spouse himself is excluded. Himself or herself is excluded.
Okay.
Now, my lord, next it has been submitted before your lordship, my lord, that my lord, it is a mistake. So, my lord, if what has been submitted, that, my lord, it is of the spouse, then it is not a mistake.
Yes.
Now, my lord, next is it has been submitted before your lordship that at LOI stage, alternate land can be provided. And, my lord, for that, my lord, the clause has been relied on. My lord, your lordship will recall, alternate land at the LOI stage can be, my lord, allotted, or, my lord, can be offered only if it is better title or better location. Simpliciter, and that too, my lord, within a particular time. Here, my lord, the time frame was also not. My lord,
same land was also
same
land was. It was argued that though it is the same land, but the moja was different.
Same land continued.
Land is the same.
And it is nobody's case, my lord, it is better title. My lord, these guidelines are framed to be complied with. My lord, I have relied on decisions, my lord, before your lordship, that, my lord, the terms of the advertisement are required to be strictly construed or strictly followed. My lord, that has not been. Now, my lord, it has been next submitted before your lordship relying on a decision of Supreme Court reported in 1991, volume 3, Supreme Court cases, page 273, that the essential conditions can be relaxed. Now, my lord, kindly come to that decision once. 1991, volume 3, Supreme Court cases, page 273.
Yes.
Lordship got that?
Yes.
Kindly come to, my lord, they have relied on 3 paragraphs. Kindly come to paragraph 3 only. They have relied on 3, 4, and 6, my lord. That is the note says. The case of the appellant has been that its tender mentioned the highest amount of 1.5 crore rupees for the 2000 metric ton of ferrous scrap, which was a very fair price, and the authorities were absolutely right in accepting the same. With respect to the alleged deficiency in the matter of deposit of the earnest amount, the stand is that a banker's check is as good as cash. And especially so when a verification from the bank in question about its authenticity was made and the bank's assurance to honor the same was obtained. So instead of cash, banker's check certified by the bank was given. That was the only difference. Admittedly, the tender committee had taken the precaution of getting the matter confirmed from the appellant's bank before deciding to accept his tender. The relevant clause 6 of the notice required the tender to be accompanied by earnest money calculated at 5% of the offer under the tender subject to a maximum of rupees 50,000 and in terms permitted the deposit by cash or by demand draft drawn on State Bank of India. The defect pointed out by the respondent number 1 and accepted by the High Court is in the appellant sending the check of Union Bank of India drawn on its own branch and not on State Bank. By the impugned judgment, it has been held that in view of this defect, the authorities had no power to accept the appellant's tender. The learned counsel for the appellant has contended that having regard to the circumstances in the case, it must be held that the tender committee had the power to accept the appellant's tender. Referring to the books on bills of exchange by biles and checks in law and practice by so and so, it has been argued that certified checks are as good as cash and the irregularity relied upon in the applicant submitting his tender could be validly waived by the diesel locomotive works. Reliance was also placed on such and such. Next, my lord, 6. It is true that in submitting its tender accompanied by a check of the Union Bank of India and not of the State Bank, clause 6 of the tender notice was not obeyed literally. But the question is as to whether the said non-compliance deprived the diesel locomotive work of the authority to accept the bid. As a matter of general proposition, it cannot be held that an authority inviting tender is bound to give effect to every term mentioned in the notice in meticulous detail. Kindly take note of the language.
Yes.
And is not entitled to waive even a technical irregularity of little or no significance. Now, my lord, here, my lord, pausing here for a moment, I would humbly submit, my lord, the points which have been raised here by the writ petitioner before your lordship, in my submission, cannot be said to be of, my lord, little or no importance. The requirement in a tender notice can be classified in two categories. Those which lay down the essential conditions of eligibility and the other which are merely ancillary or subsidiary with the main object to be achieved by the condition. In the first case, the authority issuing the tender may be required to enforce them rigidly. Now, my lord, here, my lord, a godown and a showroom is required to be, my lord, established. For that, land is required. The land given, my lord, is shown to be a water body.
Yes.
And there is no, my lord, right of way for, my lord, passing a truck. Or no road. Now, my lord, in view of that, my lord, in my full submission, this decision, my lord, reported in 1991, volume 3, Supreme Court cases, page 273, my lord, has no application in the facts of the case. Now, my lord, on fact, the next submission which was made, my lord, that from the Google map annexed, it would appear that, my lord, the distance of the road is lesser. My lord, it does not, the Google map does not show, my lord, with the road which they have sought to rely on is a, my lord, motorable road. It merely shows, my lord, there is a road. Nothing further. Now, Three further decisions have been relied on, my lord. The first one, my lord, is a Bombay High Court decision, my lord, in the matter of Adani Port and Special Economic Zone in WP writ petition L number 14657 of 2022.
Yes.
Kindly come to, my lord, the paragraphs relied on 43 and 44. Now, my lord, I would humbly submit, my lord, this case and, my lord, the next case, my lord, they have no application because, my lord, it speaks about interpretation of a tender document. My lord, here, my lord, there is no question of interpreting the tender. The tender document speaks for itself. There is no question of interpretation of the tender. Now, kindly come to paragraph 43. Our understanding of the law, drawing guidance from the decisions noticed above, is that the terms and conditions of a tender are not to be read and interpreted in the same manner a statute is read and interpreted. The legislatures make law actuated with some policy to curb public evil or to effectuate public policy. As and when an issue arises before them, it is the duty of the constitutional courts to interpret the law and declare what the law is. If the court finds gaps in the working of law while interpreting and declaring what the law is, it is not precluded from ironing out the creases by appropriate technique of interpretation to infuse life into law. But it is impermissible for the courts to alter the materials of which the law is woven. Such ironing out of the creases inter alia is generally premised on the court's perception of what the legislative intent was. In so doing, courts are entitled to interpret and declare the law without consulting the legislature to explain what was intended while enacting the law. Legislative functions come to an end once the law is passed. When the constitutionality of a law is challenged or when the court is otherwise required to interpret and declare what the law is, the parties opposing, supporting the law are only heard. However, in regard to interpretation of tender terms and conditions, the perspective is completely different and such an exercise as can be taken recourse to in interpreting a statute would be impermissible. Terms and conditions in a tender are set which would advance the tendering authority's interest. When the terms and conditions of a tender fall for consideration and the need arises for the court to understand what is meant by a particular clause and what is the requirement of a particular clause in such tender, the tendering authority's version has to be heard by the court. If such version of what it intended by inserting the relevant clause appears to the court not to be manifestly unfair, utterly unreasonable, totally arbitrary, or thoroughly unjust, the court cannot substitute its view of what would have been a better course of the tendering authority to follow to achieve the object of the tender. Deference to the view of the tendering authority by the court is the general rule. The adverbs in the preceding sentence would signify a level higher than what in one's perception the requirement of a clause would amount to be seen as unfair, unreasonable, arbitrary, or unjust. When a party invokes the court jurisdiction and claims that a clause in the tender ought to be read in the manner it reads it, in such a case, the tender terms and conditions have to be read by the court and understood in the language they are plainly expressed. Even in a particular clause is ambiguous and upon a query being raised by the court as to what the clause precisely means or what is the requirement, the meaning that the tendering authority gives has to be accepted without reservation, unless, of course, such meaning contravenes a constitutional right. Now, my lord, the meaning has to be appearing from the document itself. This is because the freedom that has to be conceded to the tendering authority to choose with whom it would like to enter into a contractual relationship and the allowance of certain measures of free play and in the joints, which is a necessary concomitant for an agency working in the administrative sphere. Resting on such understanding of ours, it is now time for us to analyze clause 6. As I have already submitted, my lord, it is, my lord, not the IOCL's interpretation that, my lord, any clause, my lord, in the contract has been misconstrued by the petitioner before you.
Yes.
My lord, the next one, my lord, is 2017, volume 14, Supreme Court cases, page 514. Sorry, 514.
517.
517. Sorry. Paragraph.
Paragraph 22.
22 they have, oh, very well. Kindly come to 20. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. After this, my lord, I don't think I am required to place it. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tender or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principle of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, courts will not in exercise of power of judicial review interfere, even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual dispute. The tenderer or contractor with a grievance can always seek damage in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehill of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public work for years or delay relief, etc. Then, my lord, therefore, a court, before interfering in tender or contractual matter, in exercise of power of judicial review, should pose to itself the following question: whether, kindly take note, whether the process adopted or decision made by the authority is malafide or intended to favor someone. Let kindly take note of the facts here. First, application made, online application accepted, though, my lord, the land was not, my lord, within the jurisdiction. That was done. Then it was rejected. Then they come to court. Then, my lord, they accept the same land.
No, they prefer the court. Thereafter, during the pendency,
They
keep
the same land. They say that we are offering land. Court says that you accept their offer. Same land is offered. Court there. Court said consider. Court did not, my lord, take into consideration the land which was being again offered. Next, my lord, on that basis, on the basis of the same land, LOI is issued. Long after LOI is issued, my lord, a request was made, I want to give another land. Though, my lord, the requirement was not fulfilled. Now, my lord, if it is not intended to favor someone, my lord, possibly nothing can be, my lord, there to favor someone. Kindly take note of the next one. Or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached. Here again, my lord, kindly take note of the family unit. In my respectful submission, it does not include, my lord, father-in-law. For some reason or other, it does not include father-in-law or the mother-in-law. Next, my lord, kindly once in this decision, kindly come to paragraph 28 once.
Yes.
The limited scope of judicial review by the High Court envisaged examination of the question whether there was any material irregularity in the decision-making process or whether the decision of the committee and consequential rejection of its respondent's tender was irrational, unreasonable, or arbitrary. Now, my lord, here again, my lord, pausing here for a moment, my lord, the IOCL was not, my lord, has not also come to the court, my lord, with clean hands. They have not disclosed, my lord, the field verification reports. How, my lord, the land which is shown to be or which can be seen to be a, my lord, and water body could pass the test of field verification, my lord, nobody, my lord, has said that. The persons concerned who, my lord, went for field verification, they are, my lord, senior officers. None of them has filed any affidavit before the court. The validity of the decision of the committee taken on the material available at the time of consideration of tender cannot be tested with reference to a subsequent police inquiry report. It's not the case here. Submitted in the writ proceeding, nor can it be held that the committee acted arbitrarily in not accepting the passbook order, etc. So, my lord, the requirement is, my lord, whether there was any material irregularity in the decision-making process, and in my respectful submission, in this case, there was definitely, my lord, material. Now, my lord, the next one, my lord, they have relied on is reported in 2019, volume 14 Supreme Court cases, page 81. Yes, this is the Cartel matter.
Cartel Infotech.
Yes. Let kindly come to the facts. Initial few paragraphs, my lord, may I please?
Yes.
We've granted Hindustan Petroleum floated an public tender on both December 2017 for setting up call center for receiving, recording, and replying to information, inquiries, and complaints from LPG customers of IOC, HPC, BBC. The appellant participated in the tender. Clause 20 of the tender reads as under: 20 blacklist, ban, holiday list. Bids received from parties who have been banned, blacklisted, put on holiday list, or parties in respect of whom the action for blacklisting and holiday listing has been initiated, etc. They, my lord, cannot be considered. Then kindly come to paragraph 2. The appellant was issued a show cause notice on 5th December 2017 in respect of another tender. That is after floating of the tender, but before submitting the bid for blacklisting on the allegation of furnishing false information and bid documents submitted for providing Kishan call center service to the Department of Agriculture, Cooperation and Commerce Welfare. The show cause notice alleged that on question being raised about the correctness of information furnished by the appellant in the bid document regarding running of call center at different locations, an inquiry was made through officers, and despite further information being sought, the same was not forthcoming. The operative portion of the show cause notice reads as under: Accordingly, in the above circumstances, a situation has prima facie emerged that Messrs. Cartel Infotech has endeavored to procure the above tender by providing false, misleading, and wrong information. Therefore, the department hereby issues notice to Cartel Infotech to show cause as to why suitable action for blacklisting of the firm should not be initiated.
Yes.
Then 4. The appellant submitted the bid in respect of the e-tender on 19th December 2017. In terms of clause 20 extracted aforesaid, a format has been provided for the declaration to be made, which is as under. Then, my lord, the format is given. Next, my lord, kindly come to just above paragraph 5. The appellant submitted the declaration in terms aforesaid, that is stating that the appellant had not been blacklisted by any government or quasi-government agency or public sector undertaking. Appellant also submitted an undertaking once again in the prescribed form. The format of the undertaking is as under. Now kindly come to the next paragraph. The respondent number 1 paragraph 6. Respondent number 1 evaluated the technical and financial bid and declared the appellant as L1 and respondent number 3 as L2 on 16th January 2018. The letter of acceptance of the tender awarded to the appellant was issued on 12th February 2018 for a value of rupees such and such. Then paragraph 7, respondent number 3 filed a writ petition in the Bombay High Court on 17th February 2018, assailing the declaration of the appellant as L1, the purchase order in favor of the appellant confirming the order of contract and mode of payment was issued on 21st February 2018. One day later, on 22nd February 2018, the Ministry of Agriculture and Farm Welfare passed an order of blacklisting.
Yes.
So when the application was made, there was no order of blacklisting, and that was the declaration given. Now on this basis, my lord, now kindly come to paragraph 37 once. They have possibly relied on paragraph 39.
39.
But kindly come to paragraph 37. We considered it appropriate, Lordship got that? We considered it appropriate to make certain observations in the context of the nature of dispute which is before us. Normally, parties would be governed by their contract and the tender terms, and really no deed would be maintainable under Article 26 of the Constitution of India. In view of the government and public sector enterprises venturing into economic activities, the court found it appropriate to build in certain checks and balances of fairness in procedure. It is this procedure which has given rise to scrutiny of tenders in writ proceedings under Article 226 of the Constitution of India. It, however, appears that the window has been opened too wide, as almost every small or big tender is now sought to be challenged in writ proceedings almost as a matter of routine. This in turn affects the efficacy of commercial activities of the public sector, which may be in competition with the private sector. This could hardly have with the objective in mind. An unnecessary close scrutiny, kindly take, an unnecessary close scrutiny of minute details, contrary to the view of the tendering authority, makes awarding of contract by government and public sector a cumbersome exercise with long drawn out litigation at the threshold. The private sector is competing often in the same field. Well, it does not apply here. Promptness and efficacy level in private contracts are often taken to make the tender of the public sector a non-competitive. Then, in Afghan infrastructure versus Nagpur Metro, this court has expounded further on this aspect while observing that the decision-making process in accepting or rejecting the bid should not be interfered with. Interference is permissible only if the decision-making process is arbitrary or irrational, to an extent that no responsible authority acting reasonably and in accordance with law would have reached such a decision. It has been cautioned that constitutional courts are expected to exercise restraint in interfering with the administrative decision and not to substitute their views for that of the administrative authority. Mere disagreement with the decision-making process would not suffice. Another aspect emphasized is that the author of the document is the best person to understand and appreciate its requirement.
Yes.
In the facts of the present case, the view on interpreting the tender document of the respondent number one must prevail. Respondent number one itself appreciative of the wording of clause 20 of the format has taken a considered view. Respondent number three cannot compel its own interpretation of the contract to be thrust to the respondent number one or ask the court to compel respondent number one to accept that interpretation. In fact, the court went on to observe in the aforesaid judgment that it is possible that the author of the tender may give an interpretation that is not acceptable to the constitutional court, but that itself would not be a reason for interfering with the interpretation given. My lord, here, my lord, with respect, I'm sorry, my lord, at the risk of repetition, I would say that no such interpretation has been given by IOCL, my lord, in their act. My lord, kindly that is, my lord, I don't think that anything further is required.
Yes.
My lord, so far as my notes, which was, my lord, prepared, my lord, I find that, my lord, the private respondent has really, my lord, relied on a list of dates and, my lord, has no further, my lord, submission was possibly made, accepting, my lord, a decision reported in AIN 1961, page 1506, which says that, my lord, if statute provides something, that has to be followed. My lord, here there is no such, my lord, statutory provision. My lord, kindly give me a minute's time, my lord. I have, my lord, concluded more or less. Kindly give me a minute's time. My lord, only, my lord. My lord, kindly once, sorry.
Yes. My lord, kindly once
come to my petition, my lord, one document and one paragraph from the affidavit in opposition of my lord IOCL. I shall place before the lordship and confirm. Kindly come to the petition once.
Paragraph?
No, page 56 of my application. Their document.
Yes.
Page 56. A document dated 4th July 2019 written by Indumati Raut, my lord, that is a private respondent, to IOCL. Prayer for approval of new plots of land for showroom and godown. Dear sir, with due respect, I would like to express that I want to change the plots of land for showroom and godown. And these plots of land are very low land and full of water. The description of the land which I proposed previously is as follows. Then, my lord, the particulars are given. Now I want to change the plots of land and I propose new plots of land for showroom and godown. The description of new plots is as follows. Showroom Mouja Atpukur, godown Mouja Kushnagor, Kushangra. So admittedly, my lord, it's a water body. They themselves admit this. Therefore, please give me approval of new plots of land and be or oblige, whatever it is. The language is not correct.
Yes.
Now, my lord, the IOCL in its affidavit in opposition, my lord, paragraph 17 says this about the, my lord, nature of the land. It is humbly submitted that the land offered by private respondent was classified in the record of right as Bilar, which means agricultural land. BLLRO Binakha 24 Parganas North has confirmed that Bilar means agricultural land. In the premises, the contention of the private respondent to the effect that the land offered by the respondent in her application for construction of godown and showroom was not meeting the eligibility criteria since the same is a water body is absolutely erroneous. It is further denied that existence of all-weather motorable road is one of the eligibility criteria for issuing LOI in favor of a successful candidate. My lord, in view of this, my lord, in my respectful submission, my lord, the lordship would be pleased to allow the writ petition and my lord set aside the decisions taken by the author. Okay. The injunction is continuing. These are my respectful submissions, my lord. I am obliged, my lord, for giving such a long time to us.
May I file my written notes of argument within 7 days? আপনি বলবেন এইমাত্র তো বললেন তো
Yes. This is item number 1. Item number 2. Okay. Not today.
Next month as
We have concluded the entire thing. We have concluded the argument, everything concluded. Only some days is required to. So next week. Next week.
Can it be 17? আগে পড়ো না তোমরা বলেছো
Come on 12 then.
Yes.
Wednesday.
Next week.
Next week.
12 at 2 p.m.
12. No, let it appear as it is appeared. Then I have to consult.
Convenient, man.
Just wait.
If possible, make it 17th, my lord. There are no matter fixed on 17th.
Then the written notes of argument has to be given time. I want to dispose of this matter in this month.
Very good, my lord. I will be assisting your lordship by filing my written notes of argument even on 17th or 12th, whatever your lordship.
No, let me fix a time. Otherwise, it is not possible. 11? 2 p.m. Yes, there. Come on 11th then. 11th at 2 p.m. Argument on behalf of item number 1. Conclude it. Item number order legal. One order legal. Argument on behalf of judge. In reply concludes. Let the matter it's for saving. Parties at liberty to file written notes of argument within 2 weeks. In item number 1.
I will be fine consolidated.
Okay. Item number 2.
There is another writ petition, my lord.
Item number 3.
Thereafter, again, another week's time for Nomita Mundo's opposition.
Nomita Mundo, who is appearing?
Parthasarathi Bhattacharya was appearing. I don't know whether his learned advocate on record is.
Come on 11th then. Okay.
I think there will be a repetition of all the submissions that was there in the repetition. So,
Then it will be short. Then it will be short. No issue.
Yes.
Let the matter appear in the list on 11th of say March 2025 at 2 p.m. for hearing on reply on behalf of the petition.
on 11th, my lord.
11th. Okay. Thank you. Thank you. Yati next one.
No.
Call the next matter.
My lord, Mr. Manavendra Singh Yadav is appearing for the Indian Oil Corporation, my lord, due to personal difficulties left for the day, my lord. Only praying for not today, my lord. Only not today.
I'm not opposing since it's a personal difficulty. Can you take it up tomorrow at 10:30? Because I'm completed my submission. Mr. Shanna leading me. He has completed his submission. They are supposed to give answer, then let's we will reply. It's not even taken a half an hour. Because they have taken third time, they have taken time.
No, I understand. That is not the issue. Item number 4. Only item number 4.
Only item number 4, my lord.
Tomorrow 10:30 you are ready.
10:30.
No, 10:30. I have some other matter.
Lordship's convenient.
Okay, 10:30 fixed as well. Okay. 10:30 as well. 10:30. Huh? দুটোর সময় আচ্ছা tomorrow at 2 p.m.
Simple.
I have already fixed 2 matters tomorrow at 2 p.m.
These are partner matters. It is also partner matter. If the hearing start, it will be taken 15 to 20 minutes.
Yes.
Not more than that. That's why all the matters like that. Not today. Next.
So may I please, Your Lordship, today I was only to give reply. They have completed their part of submission. Your Lordship, remember there is a tender matter where I was selected as the H1 bidder, but thereafter the work was not allotted to me. This is with regard to distributorship of LPG gas in Dhubguri. Your Lordship remembers, I'll just give a brief overview, then I will distinguish the judgment that they have given. Brief overview of the matter is that in a tender, in an open advertisement, I participated. I was selected as the H1 bidder. I have satisfied all the conditions. Field verification was made. They have given a report that LOC should be given to me. So till this stage, my right has been accrued. Subsequently, thereafter, for some reason or the other, they failed to give the distributorship to me, which constrained me to file a writ petition seeking a mandamus that the distributor should be granted in my favor. Okay, dates are very important. I have been appointed. I was declared as a successful bidder on 31st of May 2018.
It has joined up to Supreme Court in the other case.
Yes, matter what has happened thereafter during the filing of the writ petition in October 2018, 5 months after I have been declared as the H1 bidder, I got to know from the writ petition, from their pleadings filed, that one Bimola Gas Service, who was earlier appointed as a distributor, his distributorship was terminated in 2014. Now, challenging that, he has filed a writ petition. He won in the single bench. He won before the division bench. IOCL went to Supreme Court. SLP was not entertained. When I got to know that there is a Supreme Court appeal pending, I intervened. Supreme Court said that all issues are kept open.
Yes.
All issues are kept open. Now, Bimola Gas Service got that distributorship restored on 5th October 2018, whereas my selection was in 31st of May 2018, 5 months before. Now, during the pendency of my writ petition, IOCL has not disclosed this fact. I came to know, I filed a supplementary affidavit pursuant to direction of the Honorable Supreme Court. So the important factor is that in the writ petition filed by Bimola Gas Service from 2014, when I have been selected as the H1 bidder, IOCL was aware of this fact. IOCL did not bring this fact to the knowledge of the single judge. If this would have been brought in the knowledge, then the fate could have been different. Single judge would have at least directed them to give us a notice so that we are added as parties. Only after hearing effective order could have been passed. Because I was a necessary party. If you give the distributorship to someone else, though I have been appointed subsequently, then my rights are affected. Without hearing the necessary party, this order would not have been passed. Now, I filed a writ petition. Order was passed initially on 23rd of March 2021 by the Honorable Single Bench that yes, since he has been selected as the H1 bidder, he has a valid legal right has accrued in my favor. So his appointment cannot be cancelled. The declaration cannot be cancelled without.
You are not appointed. LOI.
No, not been appointed. Declared as the successful bidder.
Yes.
So once the court said that once your right has accrued, your appointment cannot be cancelled for flimsy grounds. So the IOCL was directed to file an affidavit saying that considering the situation of this case, you file an affidavit showing that whether there is any bar that in respect of the same municipal area, whether more than one distributor can be appointed or not. They filed an affidavit, but they failed to disclose any rules and regulations which restrains them from appointing another distributor in the same area. Now, in the affidavit, they said that if the ceiling limit, if the refilling limit of LPG gases are more than 12,000, yes, second distributor can be appointed in the same area. That means there is no legal bar that two distributors cannot be appointed. It depends upon the refilling limit.
Yes.
In support of that, they only made a statement, but they could not produce any documentary evidence. Rather, I have taken an exception to their own affidavit, where I have shown that the number of household in Dhubguri municipality is 14,328. Now, concrete facts are not before me with regard to what will be the refilling limit, but if it is assumed that even one household requires one cylinder a month, then it goes above 12,000 because 14,000 is the household number of.
They are taking the 2011 census.
They are, yes, no, I am relying upon 2011 census. They have made a statement in their affidavit that as on date the population is 9054. To counter that, that's a mere statement, no documents. To counter that, I have relied upon a Sensex statement of 2011, which says that the number of population is 44,000, more than 44,000. And households are 14,328. That is a certificate issued by the municipality itself. Now, if I take it, Your Lordship, one household will at least require 1 cylinder a month. If that is taken into consideration, it goes above 12,000. Once it goes above 12,000, as per their own submission, then as per their own statement in the affidavit, then more than 2 distributors can be appointed. So these are the facts of the case. There is no legal bar.
Yes.
Now, I have cited few judgments to show that first of all, the order which was obtained in the writ petition of Bimala Gas Service regarding the restoration of that distributor when I was already appointed, IOCL was aware of the fact, has not disclosed, amounts to an order passed behind my back without making the necessary party, I being a necessary party to the writ petition. So my submissions, my contentions were not heard. So that order is not binding, and this order has been obtained behind my back, which amounts to fraud. Fraud vitiates every solemn act, so that order cannot be binding upon me. My independent legal right arising out of my selection as an H-fund bidder cannot be affected in any manner whatsoever. That legal right has to be looked into and considered by this court independently. The second line of judgment which I raised is that if I were a necessary party, if any order passed in a proceeding will affect the right of a third party, then that third party has to be made a party. If that necessary party is not added and an order is passed, then that order is null and void. That cannot affect the rights of a third party. The third line of judgment which I have placed before this honorable court is that since in the writ petition of Bimala Gas Service I was not made a party, any order passed, I can choose to ignore that order because it does not affect my right. It might be the case that Bimala has gone till Supreme Court, his distributorship has been restored, but that is his independent cause of action. IOCL has to look for the distributorship. IOCL has to consider the distributorship separately. But with regard to my right, IOCL cannot deny. Because that order is not binding, I can choose to ignore that order. And the fourth line of judgment which I placed is on the ground of promissory estoppel and legitimate expectation. That if a party, if a government body has acted in a manner which has led the other party to believe that if he acts in this manner, I will get the benefit of the transaction. And during that process, I have altered my situation. Then they are barred by the principles of promissory estoppel. Even if this is the case contention of the other side that there is no valid contract because I have not been appointed.
Yes.
Promissory estoppel is on the principles that even if there is no valid contract, if you have acted in a manner which amounts to a promise to the other side, other party, who has also acted as per your promise, then you cannot backtrack from that promise. You cannot say that, no, I will not adhere to the promise that I made. Because that is the principles for promissory estoppel. And legitimate expectation, why? Pursuant to the tender, I have deposited the money. I have procured land for setting up the godown. That is amount to changing of the alteration in my situation. I have given the money. You have done the field verification. You have said that this is a fit person to be given the LOI. Now, all this conduct on the part of the government creates a legitimate expectation on my part that yes, I will get the tender.
Yes.
So on those principles, the state government authority cannot deny my right to get the tender. Now, if your lordship wants, I can again place my judgment, which I have placed if your lordship wants, because your lordship is hearing the matter after a long time.
I know, but not necessary to again.
No, if your lordship wants only.
Yes.
Otherwise, I can just distinguish their judgment which they have placed.
You can distinguish their judgment.
I have filed a written note, but your lordship, this point of promissory estoppel and legitimate expectation, which I have argued, I have showed judgments, that is not included in my written note. So if your lordship allows me, after I complete the submission today, I will file an additional written.
Okay.
Your lordship, the first judgment which has been placed, which the private respondent Bimala Gas Service has placed. Your lordship will find 2012 SCC online 4377. All these judgments your lordship will find which has been placed either by the IOCL and Bimala Gas Service on the same line, that all these judgment relates to a recruitment process in a service jurisprudence.
Yes.
My case does not relate to any service, does not relate to any recruitment process in a particular organization. All the judgments are with regard to service, appointment into a particular post out of the selected list of empaneled candidates. Now, there the court has held, and I bow down, there is no quarrel to the proposition. I concede to that if there is a list of empaneled candidates and there is a particular post in the organization to be recruited, then the empaneled candidates, selected candidates in the list does not get an automatic right to be appointed in that post. Because
Empaneled
the
candidate has no right to get appointment.
No right.
This is the their
correct. I bow down, but that is not applicable herein. Why? Why if a particular there is a selected list of empaneled candidates. Now it depends upon the ultimate discretion and authority of the organization whom to appoint. And all these judgments with regard to the recruitment process are guided by rules of that particular organization, either IPS rules or IAS rules. So all these judgments says that if the recruitment rules does not allow a selected candidate to be appointed, you cannot do that. Now, my case relates to a tender where there is no list of empaneled candidates. It is not a recruitment process in an organization. There are no selected candidates apart from me. I am the H1 bidder. So if you have to give the tender, I am the only person to whom you can give the tender. I am not getting recruited in any post. My right to get the tender is not governed by any statute or any recruitment rules. So these judgments on these points are completely not applicable. They're factually completely different. I will distinguish one by one.
Yes.
Lordship takes the first judgment, 2012 SCC Online, Calcutta 4377. The Lordship has got this is the judgment of our Calcutta High Court only. Kindly see the facts of the case first.
Just wait, let me find it out.
Whatever judgment your Lordship gets first, your Lordship will tell me, I will distinguish that. Your Lordship is not getting the judgment. Whatever Lordship judgment has the first, I will, your Lordship tells me, I will distinguish that.
1997 10 SCC.
Yes, yes. It's there with me. I will distinguish here.
Ache?
They have filed a compilation, I believe. That will.
Yes. They have filed the compilation. I've got it.
Your Lordship,
yes.
Your Lordship, the first judgment is in the compilation is 2012.
Yes.
Yes. Your Lordship will see the facts, para 1 onwards. Why I am showing the facts, Your Lordship, because that will be very relevant. On what grounds this principal law was set down. Having heard the learned advocate for the parties and upon perusing the writ petition, which has been taken out by 29 individuals who have joined as co-petitioners, it appears that all of them were participants in the selection process initiated by Noihati 2 Child Development Project Officer, ICDS Project, District Birbhum, for the filling up the post of Angarwani helper. The writ petitioners have prayed inter alia for issuance of a writ in the nature of mandamus, commanding the respondent authorities to approve the panel forthwith and to give them appointment. According to the learned advocate for the petitioners, having been successfully empaneled, the writ petitioners ought to be appointed as Angarwani helpers, and a writ in the nature of mandamus may be issued commanding the respondent authorities to issue appointment letter in their favor. So this facts relates to selection process as Angarwani helper, as a helper from the empanel list. This is a service matter. On the other hand, learned advocate appearing on behalf of the state replies on supplementary affidavit in opposition filed on behalf of the respondent of 3 to 6 and submits that from the documents annexed thereto it would be apparent that no consequential steps could be initiated to give appointment to the writ petitioners upon publication of their names as qualified candidates in view of various irregularities which were committed during the selection process and were detected subsequently. So, Lordship will kindly also note kind of underline this sentence, there were irregularities while making the appointment process as well. Then the next paragraph. After considering the submissions made on behalf of the parties and upon perusing the pleadings, it appears that the writ petitioners in their individual and independent capacity applied for participating in the recruitment process for the post of Angarwani helper sometime in the year 2006. Your Lordship will also underline this sentence. Recruitment process as Angarwani helper. It is admitted position that the concerned child development officer published their name as qualified candidates for selection in the post of Angarwani helper. However, there cannot be any doubt that the writ petitioners were mere participants in the selection process. Even their names has been published by the Office of Concerned Child Development Officers, qualified candidates for Angarwani helpers. Such publication cannot ipso facto translate into assurance given by the state that they will be favored with appointments. And your Lordship will also see thereafter in the middle, it is not publication of name. Your Lordship has got that sentence. It is not a publication of name of successful candidates who are to be issued appointment letters offering appointment. That apart, it is noticed that the copies of the documents annexed to the supplementary opposition that the entire selection process for the post in question was vitiated due to irregularities. So there are two factors involved here. Recruitment process in a service matter where there were imperial list of candidates. The court said that does not create any right of appointment. I bow down to that, I concede. Second, the selection process was vitiated by irregularities. So under those facts and circumstances, it was said that you do not get a right of appointment. But kindly see in my case, is there any recruitment process? Am I being employed for any job? Is there any impanel list of candidates? So facts are completely different, absolutely. This will not apply in my case at all.
Yes.
This judgment is wholly inapplicable on facts. Not a single judgment, your Lordship can take it from me, not a single judgment has been placed on any tender matter. What happens if a person is declared as an H1 bidder and there is observation has been made that LOI should be issued, whether under those facts and circumstances, whether I am entitled to get the tender or not, whether I am entitled to get a writ of mandamus. Not a single judgment has been placed, all on service matters. The next judgment, your Lordship, 2021, volume 20, SCC 267. Here also, your Lordship will find the issue is that whether after a person is selected as an IAS candidate, can he choose his cadre and place of his choice of employment? Let me tell you, give your Lordship the facts of the case, then I will show what the distinguishing features are. Here, your Lordship, the petitioner has applied for UPSC in a general category, despite being an OBC candidate.
Okay.
Now, after the petitioner was selected, she found that certain vacancies in the reservation category as OBC in her own cadre is lying in her own state. Now, thereafter, she applied for a Kerala cadre in his own state. Court said that once the petitioner has given concession and not availed OBC category, then she cannot claim to be appointed as an IAS cadre in OBC in her own state as a matter of right. Under those facts and circumstances, this judgment was delivered. This is also governed, your Lordship will see, Rule 7.3 of the recruitment rules of CSC.
Yes.
Your Lordship will see the distinguishing features. Kindly take paragraph 1. The present appeal at the instance of the Union of India are directed against the order passed by the High Court of Kerala, whereby the appellant was directed to allocate the respondent herein to the Kerala cadre of All India Service. Then your Lordship will take para 3. It is therefore that the applicant filed an original application under section 19 of the Administrative Tribunal Act before the Ernakulam bench of CAT. The tribunal directed the union to allot and accommodate the applicant against the outsider OBC vacancy in the Maharashtra cadre by virtue of her merit over the candidate already identified and allotted the Maharashtra cadre. The union and the applicant aggrieved against the said order filed writ petition before the High Court of Kerala. The writ petition of the union challenging the direction of the tribunal to accommodate the applicant
in Maharashtra cadre was allowed. Also, even the original application filed by the applicant for declaring and directing the applicant is eligible to be allotted as a Kerala cadre was also allowed. Then your lordship will straight away take paragraph 16. In light of the factual background, the argument of the union was that in terms of Rule 7.3 of recruitment rules, candidates belonging to SC, ST or OBC shall be appointed against unreserved vacancies in case they qualify for appointment to the service based on the merit without recourse to the benefit of reservation. However, Rule 7.4 contemplates that candidates belonging to SC, ST or OBC may be appointed to the vacancies reserved for the candidates for SC, ST or OBC as the case may be under Rule 3 with due regard to the maintenance of efficiency of administration. It was thus contended that Rule 3 of SC, ST or OBC candidate is appointed without recourse to the benefit of relaxed standard. They shall be appointed against unreserved vacancies. However, 7.4 is an enabling provision and is an exception to Rule 7.3 that SC, ST or OBC candidate may be appointed to the vacancies reserved for SC, ST or OBC candidates with due regard to maintenance of efficient administration. Therefore, in terms of recruitment rules, the applicant was assigned Himachal Pradesh cadre as a general category candidate. In terms of subclause such and such of clause 4, the applicant has not availed any concession relaxations as admissible to OBC candidates. Therefore, she was a general merit candidate. Then your lordship, para 20. It was argued that decision to fill up 89 vacancies was an administrative decision, keeping in view the multiple factors including the availability of infrastructure for training of candidates at Lal Bahadur Shastri Academy, Mussoorie. It was contended that mere vacancy in the cadre or in a particular state does not confer any legal right for the state to demand additional officers to such administrative decision is not confined to one state alone but to the entire country. Therefore, the officers could not be allocated to the state of Kerala in contravention of the policy decision filing of 89 vacancies. The appellant also referred to the three-judge judgment of this court in Union of India vs. Rajiv Jadhav, wherein considering the allocation circular, it was held that a selected candidate had a right to be considered to the appointment of IAS, but he had no such right to be allocated to the cadre of his choice or his income. Kindly see the distinguishing factor here. Here, IAS was being appointed as per the recruitment rules.
Yes.
A person was appointed in a, though he was an OBC, but he was appointed in the general category in a particular state category. He said that since there are reservation in his own state under the OBC category, he said that I will not avail the Himachal Pradesh category, I will avail the Kerala category. Court said that no, it's an administrative decision depending upon the infrastructure of recruitment of IAS. So you cannot choose which state you will go. And your appointment does not give you a right of allocation. So these are the facts of the case. Under those facts, the court said, now my learned friend has relied upon paragraph 32 to 34. Kindly see what it is saying. The consistent view of the court has been that even if the name of the candidate appears in the merit list, such candidate has no right to claim appointment. The Constitution bench's Shankarshan Das has held it is not correct to say that if a number of vacancies are notified for appointment and adequate number of candidates are found fit, the successful candidates acquire an indefeasible right to be appointed, which cannot be legitimately denied. Ordinarily, the notification merely amounts to an invitation to qualified candidates to apply for recruitment, and on their selection, they do not acquire any right to the post. Unless the relevant recruitment rules so indicate, the state is under no legal duty to fill up any of the vacancies. However, it does not mean that the state has the license of acting in an arbitrary manner. The decision not to fill up the vacancies has to be taken bona fidely and for appropriate reasons. And if the vacancies or any of them are filled up, the state is bound to respect the comparative merit of the candidates. Then, Your Lordship, para 33. In Subhash Chandra Marwana, this is also related by the other side. The court held that the existence of vacancies does not give any legal right of a candidate to be selected for the appointment. One fails to see how the existence of vacancies give legal right to a candidate for selection of appointment. Kindly see, all these judgments are with regard to if there is a vacancy, if there is a recruitment in a particular organization,
in service jurisprudence,
and those are governed by recruitment rules, does not give you right of appointment. There is no doubt as to that. That is also not my case. But unfortunately, my case is not with regard to recruitment in a service matter. My case is that of a tender. So all these judgments on these facts are completely inapplicable in my facts and circumstances.
Okay.
And this judgment is also on the issue whether an administrative decision can be challenged or not. That is also not the case in my writ petition. Next judgment 2013 for SCC 465. Here, your lordship, the facts of the case was that the respondent number 5 herein, who was a writ petitioner, 5 before the Supreme Court was a writ petitioner, belonged to a general category candidate who challenged the caste certificate of the appellant who belonged to the OBC category. Court said that since no legal right of the respondent number 5 is being affected, none of his legal right being affected, he cannot challenge the caste certificate of another person. Now kindly see the paragraphs which my learned friend has cited, paragraph 10 and 17. This is not on the issue whether I get a right of appointment or not.
Yes.
Paragraph 10 and 17. First, kindly take paragraph 9. This is on the issue that whether I have a locus to file the writ or not.
Person aggrieved.
Yes. It is a settled legal proposition that a stranger cannot be permitted to meddle any proceeding unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffers from legal injury can challenge the action in a court of law. A writ petition under 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, where there is a complaint by the appellant that he has been a breach, that there has been a breach of statutory duty on the part of the authorities. Can your lordship kindly skip 4 or 5 lines and take the line starting from the same paragraph? It is implicit. 4 or 5 lines thereafter. It is implicit in the exercise of such extraordinary jurisdiction that relief prayed for must be the one to enforce the legal right. In fact, the existence of such right is the foundation of the exercise of such jurisdiction. The legal right that can be enforced must ordinarily be the right of the appellant himself who complains of infraction of such right and approaches the court for relief as regards to the same. 10. A legal right means entitlement arising out of legal rules. Thus, it may be defined as an advantage or benefit conferred upon a person by the rule of law. The expression of person aggrieved does not include a person who suffers from psychological or imaginary injury. A person aggrieved must therefore necessarily be the one whose right of or interest has been adversely affected or jeopardized. Then, your lordship, paragraph 17, my learned friend has lastly relied upon. In view of the above, the law of the land point can be summarized to the effect that a person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post or category cannot be permitted to intervene in the affairs. Now, your lordship will kindly see on what premise this judgment has been delivered. Kindly see the facts of the case. Now, kindly take page 467. No, I'm sorry. Kindly see paragraph 2, 3, and 4, the facts. Page 473. The facts and circumstances giving rise to this appeal are as follows. The competent authority in the present case issued a caste certificate dated 19th October 89 after following due procedure in favor of the appellant, stating that he does in fact belong to Bhil Taudi scheduled tribe. On the basis of the said certificate, the appellant was appointed as a senior clerk in the Municipal Corporation of Aurangabad on such and such date against the vacancy reserved for persons under the scheduled tribe category. The corporation referred the caste certificate of the appellant for the purpose of verification of the caste certificate scrutiny committee. The vigilance cell attached to the committee, upon conducting vigilance inquiry by its 29 December 1998, found that the appellant did in fact belong to Bhil Taudi scheduled tribe and thus the certificate was verified. A scrutiny committee on the basis of the report and other documents filed by the appellant in support of the case issued a validity certificate on 23rd May 2000 to the appellant. After a lapse of 9 years, respondent number 5 filed a complaint dated 9th January 2009 through an advocate before the scrutiny committee for the purpose of recalling the said validity certificate on the ground that the appellant had obtained employment by way of misrepresentation and that he does not actually belong to the scheduled tribe category. In fact, the appellant has professed religion of Islam and therefore could not be a scheduled tribe. The scrutiny committee rejected this said application by order such and such, observing that they had no power to recall or to review a caste validity certificate as there is no statutory provision. Aggrieved by the respondent 5 challenged the order of such and such, praying for quashing of the order of 13 March 2009 and directing the committee to hold de novo inquiry with respect to the appellant's caste. The appellant contested the petition denying all allegations. However, while doing so, the High Court set aside the order dated 13 March 2009 and remitted the matter to scrutiny committee, directing it to hear all the parties in accordance with law. Now, under these facts and circumstances, court says that since no legal right of the respondent number 5 was affected by grant of the validity certificate, because the validity certificate was issued in favor of the appellant. Since your legal right has not been violated, you cannot file a writ petition.
Yes.
But why this judgment has been shown, I fail to understand, because in my case, my right, accrued legal right arising out of the fact that I am being selected as the H1
It was
bidder.
heavily argued that by issuance of the intimation that you have been selected in the draw of lots, no legal right has been accrued in your favor. That is heavily argued.
Heavily argued, but no judgment cited on that. No judgment cited on any tender matter. Now, it is not only the draw of lots I have been intimated. By a intimation from IOCL, I have been said that the term used is that you have been selected as the H1 bidder. It is not that you are a successful candidate under draw of lot. The communication is not that. I will show. You have been selected as the H1 bidder, and subsequently thereafter, they have taken further steps by accepting money from me.
Yes.
They have conducted field
You have
inquiry.
complied with the all formalities.
Formalities, and thereafter being satisfied, they have said that LOI should be issued. So they have gone 2 steps ahead. Not only that, after the declaration, everything has ended. They have gone 2 steps ahead by making the field verification, declaring that I should be issued the LOI. But thereafter, they have not gone forward. Only because of the fact that in the meantime, the distributorship of Bimola Gas Service got restored. But that cannot be a ground for negating my legal right. I have an independent legal right.
Yes.
Now, under these facts and circumstances, this judgment was delivered. But here in my case, this is not applicable because I have a legal right which is being infringed. Because the fundamental right which has been infringed, for which I filed the writ petition, is that after being declared as the H1 bidder, you have not given me the distributorship and not been able to carry on my business. My only source of livelihood was to carry on the business of distributorship. Since you have not granted, I am not able to start. My livelihood is at stake 19(1)(g) and violation of 21. So that's why I have a legal right to file the writ, and this judgment, that's why it's not applicable. Now, the third judgment which they have placed is that 1991 volume 3 SCC, page 47.
Yes. Sankarshan Das.
Now, so this is on the case, similar on a recruitment process. There was a vacancy for an IPS job, and the recruitment rules was governed by the IPS rules of 1954. If your lordship goes through the head note, your lordship will see. Now, several candidates participated. There was a list of selected candidates who were empaneled. Now, one out of the empaneled list wanted to get appointed. Court said that it does not, your selection in an empanelment list does not create any right title interest to be appointed. Now, the relevant other side has shown paragraph 7 and 8. Kindly see after the head note, it is held. Just after the head note, the facts have been, in brief, it has been mentioned. So, your lordship it's not required to go through the entirety. Even if a number of vacancies are notified, the appointment and adequate number of candidates are found fit, the successful candidates do not acquire an indefeasible right to be appointed against the existing vacancies. Ordinarily, the notification merely amounts to an invitation to qualified candidates to apply for the recruitment, and on their selection, they do not acquire any right to the post. Unless the relevant recruitment rules so indicate, the state is under no obligation due to fill up any vacancies. However, it does not mean that the state has license to act arbitrarily. Then paragraph 8. Then paragraph 8 has been referred to, where various other judgments have been referred. Now, Lordship will take paragraph 9 of this judgment. Or if your Lordship takes the next page, page 40, brief, the facts has been stated in short. After the head note, the relevant portion of the para which I rely upon has been stated in short. The relevant portion has been taken. The appellant had not acquired a right to be appointed against the vacancy arising later on the basis of any rules. Rule 4 of IPS cadre rules and the police service. From the materials produced before the court, it was fully established that there has not been arbitrariness. The process of final selection has to be closed at some stage. So here is also a case where the recruitment was guided by a rules, impertinent list of candidates. In my case, those are not the facts. In my case, there are no other candidates who are there selected, who gets a right of appointment. This is a case of tender where I am the only H1 bidder, there are nobody else. So if they have to grant the tender, I am the only person. There cannot be any other person who has any accrued right for getting the tender. Okay. Only a request. I have a fixed matter from after 4 before court number 26, if your Lordship. Today, I am very sorry to make this prayer. Your Lordship only releases me for today. I can come back tomorrow and finish the following the other judgment.
Difficulty, I cannot fix tomorrow.
Any day, your Lordship, 2 p.m. I will. There are 6-7 judgments left. I will just distinguish them and finish it up. We're extremely embarrassed to make this clear.
Yes, I have already fixed several matters, important matters.
No, I know your Lordship has this very good habit of fixing matters and finishing it off. So we are also benefited.
Could not finish it. This is the difficulty.
Very sorry, your Lordship.
Come on, 10
March. 10 March. 2 p.m. your Lordship?
2 p.m. I have one fixed matter thereafter.
Yes, I will finish. Of that day, I will finish.
Argument on reply on behalf of the petitioner, hard in court. Let the matter appear in the list on 10th March 2025 at 2 p.m.
I am great. Extremely great.
Call the list. নম্বরটা তো হবে না। তো please. কি রেকর্ড? অন্য রেকর্ড চলে এসছে। হ্যাঁ? এই টাকা ছেড়ে দেন।
Lordship, I am for the petitioner, Lordship. Lordship, no report in the form of affidavit has been filed till today by the state respondent. Interim order has been extended till 12th March, Your Lordship. Let the further interim order be extended.
Let it appear on 12th March.
12th March.
Let the matter be appeared on
Let the
12th
father,
March under the same heading. Twenty-nine
my senior counsel is not available for at this time, so I'm praying for make this matter as the part heard and fix another date.
Not parted, come on tomorrow.
Oh, obliged. I will.
Not today. Next. 30, 31, 32.
33, Lord, I am for the petition. This is evidence service, Lord. Lord, petitioner is the wife of deceased Lutfar Rahman Mullah, who being a license holder of MR dealership of the by the concerned estate authority. After demise of Lutfar Rahman Mullah, my Lord, petitioner made an application for appointment of MR dealership on compassionate ground. Last occasion, your lordships gave me leave to liberty to give me to file afresh. And Lord, in this regard, I have made an application for RTI, my Lord, but that was not taken into consideration at the very outset, my Lord. They have refused the letter, and my Lord, again, my Lord, I made a representation before the authority concerned, but my Lord, that is on page, my Lord, 89, but I did not get any feedback till today. But my requirement is this, my Lord, man, kindly have a look, page 86. That please give detailed information with regard to memo number such and such in connection with
This
the
is
proposed
application of 2008.
2000.
Your
No,
application for compulsory appointment of 2008.
but it is continuing, my Lord. Process is continuing. It was 16 probably, my Lord. This is a change brief actually, my Lord. 2016, my Lord.
No, your first document, what is the medical incapacitation?
But kindly have a look, my Lord, page 75. That is your lordship's order. Annexure P12.
75.
Yes. Page 12. And page 12. Annexure P12, page 75, my Lord. May I read it?
Yes.
The husband of the petitioner, namely Lutfar Rahman Mullah, was granted MR dealership by the concerned estate authority. It is the case of the petitioner that after demise of her husband, she preferred an application for appointment of herself as a MR dealer on compassion ground. The said application was not considered by the authority concerned. Accordingly, the petitioner approached this court in a WPN number 18249 of 2016, wherein this court has given the liberty to the petitioner to file a separate writ petition afresh on the basis of self-serve cause of action. The present petitioner has submitted his demand of justice to his learned advocate via a correspondent dated 16th August 2024. And I said 11, it is the case of the petitioner that the concerned authority has not taken any decision in respect of the said representation petitioner seeks necessary direction upon the concerned authority so that the concerned authority to make a reasoned decision after giving reasonable opportunity of hearing to the petitioner. Learned counsel appearing on behalf of the state submit that she possessed the entire instructions from the authority concerned, but if the petitioner intends to proceed with the representation, necessary direction may be passed by this court. Having heard the learned counsel for the parties, it appears to me that the concerned authority has not taken any decision till today on the basis of the representation of the present petitioner through his learned advocate dated 16th August 2024. Under the above observation, the authority concerned is directed to take appropriate decision on the basis of the representation dated 16th August 2024 of the petitioner, weighing NSFP 11 to the writ petitioner and was a reasoned order after giving reasonable opportunity of hearing of being heard to the petitioner. The authority concerned is directed to take appropriate decision within a period of 6 weeks from the date of communication of this order. The authority concerned must have heard the petitioner before passing reasoned order. The authority is also further directed to inform the reasoned order to the petitioner within 2 weeks after passing reasoned order. Under the above observation, the application being WPA number suggestion is disposed of. Thereafter, my lord, reasoned order was passed. That is P13. Next page, 78. Reasoned order was passed, my lord. Same thing. That is while my lord, that is the as per the direct instruction of the competent authority of the department by e-file number such and such this dated at 19/9/2004 in connection with the WPA number 21357 of 2001, Murshida Begum first petitioner, State West Bengal and others. Respondents, a personal hearing of Murshida Begum was held on 28/10/2024 at 3 p.m. at the office chamber of the undersigned. The reason recorded deposition after scrutinizing all the relevant documents and deposition of personal hearing. Now, the undersigned also informed that her at the time of personal hearing on 28/10/2024 that her application does not arise as a compassionate case because the FPS concern was not tagged due to the death of the dealer. My lord. As a result, the prayer of Murshida Begum for engagement as FPS dealer on compassionate ground has already been rejected by the competent authority of the department by memo number such and such this. The same was intimated of Murshida Begum, wife of such and such, by the office undersigned memo number such and such this. Not tagged due to the death of the dealer. But my lord, prior to expiry, he was medically fit. He wants to return back the license, but his license was not returned back to him.
Then that is the separate issue altogether.
No, license was not returned back to him. For what reason? That was not given. That is why your lordship asked me to prefer an RTI. I made an RTI, but flatly they have refused that letter, my lord. Flatly they have refused. Why? Kindly see, my lord.
No, this is your writ petition for getting a compassionate appointment.
Yes, my lord.
But
Compassionate
there is
appointment.
no such issue of compassionate appointment.
No.
Because your husband license was cancelled.
No, that was not.
He died during the pendency of the license.
No, not cancel, my lord.
Yes, you are intimated on 20th of order dated 20th of May 2016. The matter has been disposed of finally. Why you again want to re-agitate the matter?
No, my lord. Kindly see, my lord. Your lordship kindly give me liberty. That is page 15, page 84. Page 84. That is the liberty was given to me to file afresh another writ petition. Why, my lord? Because before expiry, he took leave from the authority concerned. Thereafter, my lord, he was medically fit. Thereafter, his license wasn't returned back to him.
Not returned back.
No.
Then that is the separate issue.
Thereafter, he expired.
Then he expired.
Yes.
Then his license was already
Now
terminated.
he expired. They are explaining.
No.
Yeah.
That is you don't have any right to ask for the compassionate appointment. Is there any right? Is there any right for you to get the compassionate appointment?
No, compassionate appointment, my lord. Kindly see what they have said in the reason order, that in earlier occasion they have said identical order. In identical order, they have said that. Well, kindly see page 60 with reference to page 60, my lord.
I find nothing in your writ petition. Nothing is there.
No, my husband was a bona fide license holder. So his expiry, my wife has come to pray for an application for on
When he expired, he was not a license holder, admittedly. So why the wife
No,
required?
his license, he took leave.
No.
Yes, my lord.
He was
He was a
terminated
license
due to
holder.
No, he was not licensed. You admitted that he is not licensed.
My lord, that was not given to me whether his license was terminated or not. That is why I made an intimation, RTI. That was flatly refused.
No, you cannot ask for compassionate appointment. Can you ask for compassionate appointment when your husband had no license at the time of death? Whatever may be the
my lord,
reason,
what happened actually?
whatever may be the reason, your husband had no license at the time of his death. Okay, so you cannot ask for
my lord, that is hide and seek policy. They have chosen a hide and seek policy. What I'm saying, right? Because, my lord,
No. You just read your first document. Why you are stating like that? Your husband said that his license was cancelled due to incapacitation. Thereafter, he made an application for again getting the license, but it was not
no,
given.
my lord, he was sick. That is why he took leave from the competent authority for his treatment, my lord. Thereafter, my lord, after his medically fit, he again prayed for return back his license. But his license was
not given. Then why you have no right.
Thereafter, he expired. Then
you have no right. You have admitted that you have no right. Okay. Please take down.
But when he was alive, my lord, his husband, when his husband was alive, his license was not terminated. My lord. He took a leave from the competent authority for his treatment. Thereafter,
read your
my lord, his
first
license
document.
after his my
You
lord,
read your first document. Your husband stated that his license was terminated. He wanted to get back it.
Yes.
Then it was not given back. Then you have no right.
Not given back. That is the for which reason that you have asked me to file an RTI. I made an RTI.
No, you got the RTI or whatever maybe.
But
there is no cause of action in this case. If you receive the RTI, you can proceed other way, not by this way. Okay. Petitioner challenge a reason order of the competent authority dated November 5th, 2024, which was passed in pursuance to the direction of this court dated September 2nd, 2024, passed in WPA 21357 of 2024. Petitioner filed this writ petition with a prayer that the license which was issued in the name of her husband may be given to her on compassionate appointment, on compassionate ground. Full stop. It further appears that the petitioner herself did not challenge the order of the competent authority or never paid for setting aside the order dated 5th of impugn order dated 5th of November 2020. The brief fact of this case is that the husband of the petitioner, namely one Lutfur Rahman, was a MR dealer. The license of Lutfur Rahman was terminated on the ground of medical incapacitation. After he became fit, he filed application before the authority concerned for getting the license back. His prayer was not considered, and during that period, he expired. The petitioner approached the authority in the year 2008 for getting license of her husband. Full stop. The matter went up to the district controller food and supply, wherein the district controller by memo dated 12th of May 2016 has intimated the concerned joint director license that the prayer of the petitioner cannot be considered on compassionate appointment, as the FPS concern was not tagged due to the death of the dealer. He again approached this court, wherein this court has directed to dispose of the representation. Filed reason order dated 5th of November 2024. The authority concerned has opined that, opined as follows. Page 78, set of code. Reason order. Having heard the learned counsel for the parties, it appears to me that the prayer of the petitioner is not tenable in the eye of law, full stop, as the license of her husband was not terminated, stroke ended due to the death of her husband, her prayer for compassionate appointment cannot be considered. I make it clear that the prayer of the present petitioner on compassionate appointment was earlier turned down by the authority. Appointment was earlier turned down by the authority concerned. Thus, I find no illegality or unreasonableness in the impugn order dated 5th of November 2024 passed by the competent authority. Under the above observation, the writ petitioner is disposed of as devoid of merit. This petition disposed of as devoid of merit. Next.
Item number 29, Lordship has been hearing.
I have called it, but they are not there. So I fixed it tomorrow.
But tomorrow will it be at 10:30? Very short matter. I won't take much.
I know, but 10:30 some other matters are there.
Immediately thereafter, then
in a motion matter, it will be appear.
Very well. I was praying for some precedence because very short matter. I won't take more than 5 minutes of your lordship's time.
Item number
29. Obliged, my lord.
It would appear in the mention matter.
There.
There are few matters should be mentioned matters.
Obliged.
Well, in this matter, I am appealing on behalf of the petitioner led by Mr. Lahiri. Mr. Lahiri is out of station, my lord. I am praying for this week, my lord. He is not available this week, my lord. That is.
You are the petitioner, you are not ready to do the matter. So what can I do?
It is present.
A private respondent is also present. But my lord, I cannot oppose my learned friend's prayer.
State is represented through their learned counsel. Private respondent, full stop. Private respondent is also represented. Petitioner seeks accommodation for 1 week. Let the matter be urgent to release the matter on 11th of March.
May I say this, my lord, to make things easier, my lord, in short. But I have prepared a very short affidavit because it's only, my lord, 4 allegations that they have against me.
He is not ready to.
No, I will give, my lord, a copy of the affidavit, just dealing with the allegations. And I'll give a copy to the state and to lordship as well. So that on the next date, my lord, they come prepared, my lord. Again, my lord, otherwise they'll say that they've just received it and therefore they are not ready. Since your lordship is giving a week's time, therefore, my lord, I'm giving this copy to them. There is no direction. But I have prepared it because I came prepared today. I wanted to get this dismissed.
Not so hurry. Not so hurry. Come on 11th March. Come on 11th March. Yes, next. Not this week. 35.
I told Mr. I was telling this is 35. He said no 36. So I was waiting. He was also waiting.
So the selection process has been initiated.
Yes.
I became eligible candidate.
Okay.
The inquiry has been conducted. Then I made a representation. Since no decision has been taken, if you want to kindly turn to page 23. Although not so happy one, page 23 is my representation dated 16th of January 2025. But today I shall pray before your lordship, if your lordship pass an order directing the district controller of food and supplies to consider my petition as treating the petition as representation and take a decision. My learned
Was there anyone selected?
No, nothing has been.
But in the petition it is said that the recommendation has been made in favor of respondent number 6.
Yes.
Which is incorrect.
Not recommended.
Because it is selection is still under process.
Right.
My learned friend may have a special knowledge.
No,
but so far the substitution controller is concerned.
Today I am saying no name has been recommended till now.
Okay. So
it
I
has
am
been
not
stated on
considering any prayer, any observation,
only
any
consider.
aberration in the
This is my premature application, if I may say so.
Now my case is that, my lord, despite fitness and everything.
What is the grievance?
The grievance is that, my lord, decision has been taken, everything has been concluded.
So that is something they
there is a provision which time you have to do it. Kindly see the date of inquiry.
So when you made the representation?
January.
16th of January.
My lord. 2 months expired, more than. Your lordship, I direct the district
selection is still under process. That's my specific instruction. And my lord, there is no recommendation on behalf of in favor of the private respondent as alleged in the writ petition.
My specific case then in that case, your lordship, kindly come to page 23.
Yes.
First, second, third, fourth. That in any circumstances, the said Malara cannot be considered as eligible candidate. This is my specific case. A candidate who did not fulfill the minimum eligibility criteria, his name has also been declared as eligible candidate. So I made a representation not to consider his candidature. Now this representation may be considered and decision may be taken whether she is eligible or not.
It is under process.
Yes, under process.
Under process.
But she should not come within the zone of eligibility.
That the authority will decide. He cannot dictate. He cannot dictate the authority. 2 inquiries have been held in respect of petitioner and in respect of private respondent, and those have been sent to the apex authority, and that is under process. unless and until some decision is taken, well, this is premature application.
This is kindly see, my lord, the
And
selection
he
process
cannot
when
dictate the
instruction
authority
started.
as to how they will act. If
No,
there is
I
irregularity,
can understand if the selection procedure concluded or anything.
it's not
has been
concluded.
done,
It is under process.
it's
My
under process.
specific case is that, my lord, the person who applied along with me, my name has been recommended, her name has also,
Maybe the authority has also been cancelled his candidature.
her name has also been recommended. My specific case is that her name should not have been come within the zone of consideration.
That the authority of
No, how can you understand that the authority
Yes.
concerned had taken his zone of consideration?
This
or
is my affidavit on oath. Let them take a decision. Who is the best candidate?
On oath,
during
you have
the
said is
entire
recommended.
procedure of selection, whether any decision is sufficient, whether a decision.
That I also don't know. I made the representation. They have not intimated me anything. That I also don't know.
But only on presumption, my lord.
Not presumption is that, my lord, recommendation. My
So where is the
specific case.
recommendation? It is not
Because
there. On,
there are 7
very hot
candidates.
and cold. There is no recommendation. Then sir, how he is considering?
There are 7 candidates. Out of that, only, my lord, 2 have become eligible. Then both the name has been recommended. That's my specific case. I have categorically stated in my petition as also paragraph, kindly turn up, how her name has been considered and dealt with.
What is page 32?
Page 32.
The result of selection has to be there for my learned friend's client to be agreed.
Page
with
32
by.
is in respect of
That nothing is there as on date.
Page 32.
in
the
respect
one-
of selection process of other.
Mohammed
No, this is not any related. My case is that the second inquiry is also permissible. For that, I have annexed a document showing that in respect of separate location on the pair of the one of the candidate, fresh selection has been conducted, fresh inquiry. That for that reason, these are no relevancy so far today's case is concerned, because subsequently inquiry has been conducted, second inquiry has been conducted. My space.
Your go down also.
Yes, they satisfied. They recommended my name. This is not the case of the state. Inquiry officer recommended my name along with other candidate. My specific case is that that candidate did not come within the zone of consideration, being not an eligible candidate. Let them take a decision. If I am wrong, they will reject my application.
Not at his instance.
And they kept.
No, it is very fair. The authority concerned has initiated a procedure.
My lord.
Okay, under the
Control.
at the vacancy. Under
And
the control order,
inquiries,
they have
separate
proceeded,
inquiries have been held
and
in respect
it
of
was not
petitioner.
concluded. Now, within that period, whether court can intrude.
Yes,
Subject to lordship consideration.
that's what I am
Your lordship
submitting.
known, there is a time bound. Everything.
I understand time bounding is
That
there.
time expired more than 6 months. In that case, I can pray before the authority concerned or the High Court also that you conclude the selection process within certain time.
That can be done.
That
Yes.
decision may be illegal, and he will have a chance to
No,
challenge
you have to
that,
conclude
but
the
not
select-
now. Lordship can recognize
no,
it's a
no.
premature one.
No,
Two inquiries have been
no,
held in
no.
respect of the petitioners and respondent number 5. And I don't know whether respondent number 5 has been served or not.
You have to short to sharp. I must be candid one. That has been written.
That it is for him to.
No, I am not saying that to provide opportunity of hearing to me.
Now,
All candidates.
inquiry reports are pending consideration by the competent authority.
Mala,
At this
this-
juncture, your lordship
Returned, it has been
is
returned.
not called for at all.
Your lordship knows from the date of application, inquiry 15 days. From the date of inquiry, return, my lord.
That must culminate in an order of the authority.
If
it
you
is
kept
yet
the
to
matter
culminate.
pending for indefinite period,
Where is the culmination?
the rule says within 15 days you have to conduct the inquiry. Thereafter,
That will
hearing
initiate the
within
order if any.
Every steps there are
yes,
time is there.
that 6 months expired instead of 1 month. Kindly direct the authority concerned to conclude the selection process
Well,
in accordance with the merit.
That process has 6 steps. I have got in, and those have been done already. Now, my lord, the inquiries have been held, 2 separate inquiries, and those have been sent to the authority to take a decision. Now, my lord, where is the my lord,
Okay. Hard.
he is not a aggrieved party at all.
Okay.
The petition is not maintainable; it's a premature one, and lordship may not interfere with the selection process. That's the executive domain, not the domain of the High Court.
Yes.
You may keep it pending for 5 years also.
That law will take its own course.
That is the law. I'm coming to the court of law.
But you are not the agreed person as of date.
Definitely agree person. You are not concluding the selection process. I have taken a rented room. I have to pay rent every month. You kept the matter pending for last 6 months.
Your Lordship kindly records my submissions in a nutshell, and then whatever your Lordship please.
Petitioner applied for FPS license in terms of notification dated 13th of May 2024, issued by the SCFS Jhargram. Full stop. It is the case of the petitioner that the entire selection process was conducted by the authority concerned, adopting a method which is not known or violating the provisions of the Control Order 2013, Control WBPDS, MNC within bracket Order 2013. It is the positive fact of the petitioner that the petitioner was recommended as a qualified candidate, including one candidature, namely Mala Rai, within bracket respondent number respondent number 6. Accordingly, he made a representation to the authority on January 16, 2025, which was not considered by the authority. So he prayed for necessary direction upon the authority concerned. Next, Mr. Dotto, learned counsel appearing on behalf of the state authority, raised strong objection and submits that the entire selection process is yet to be concluded. Full stop. The petitioner candidature has not been cancelled or authority has not taken a decision. Accordingly, the petitioner cannot be termed as aggrieved candidate. He further submits that the instant petition is premature one, so it is liable to be set aside.
Dismissed. Liable to be dismissed.
Liable to be dismissed. It is the further contention of Mr. Dotto that the read court cannot intrude himself into the selection process.
Executive domain, I said.
Directing the authority to take a reasoned decision during the pendency of the entire process. It is a purely executive domain of the authority before taking a decision.
And there is no culmination. I also submitted there is no culmination of the selection process as yet.
He further submits that I have taken the note. Having heard the learned counsel for the party, it appears that Mr. Sahara, learned counsel appearing on behalf of the petitioner, submits that the selection process was adopted on the basis of the impugned notification dated 13th of May 2024. Since then, they are delaying the process. So necessary direction may be passed upon the authority to conclude the entire selection process promptly. Having heard the learned counsel for the parties, I make it clear that the entire selection process is yet to be concluded. So at this juncture, the authority concerned has to take a decision according to the law in selecting a suitable candidate for the said vacancy. Moreover, the candidature of the present petitioner was not rejected or any person was not appointed. In that score, I find no justification to pass a specific direction upon the authority to consider the representation of the petitioner. However, the authority must act according to the direction of the Control Order 2013 to conclude the entire selection process. I have observed that the selection process has not is yet to be concluded. Thus, the authority concerned has not followed the directives of the Control Order 2013 to conclude the selection process within a specific time. At this juncture, I think it necessary to pass a direction upon the authority concerned to dispose of the selection process
Or conclude
as
the
early as
session.
possibly, as early as possible. More preferably within 6 weeks
I'm getting it. Much appreciated.
from the date of passing of this order. Next paragraph. As now, since no affidavits has been exchanged, no affidavits have been exchanged between the parties, comma, the allegation made in the writ petition shall be deemed to have been not admitted. Full stop. I make it clear that this court has not entered into the merit of this matter. The authority concerned had to select the suitable candidate according to the law.
But Your Lordship has
Election process will be completed within 6 weeks
Within 6 weeks.
from the date of commission of the order.
But Your Lordship has stated that selection process shall be disposed of instead of concluded. The selection process must be concluded within 6 weeks. Your Lordship has-
Concluded.
Your Lordship has recorded
I have
possibly my lord,
disposed of.
disposed of.
Very concluded.
I'm getting it.
Lordship, in the next matter, your lordship, item number 36. Your lordship, I'm praying for a note this week, your lordship. Mr. Sanjeev Kumar. Molly,
You are
I'm for the BPCL respondent number 124.
private respondent? No.
No, I'm not the private respondent. He's for the private respondent.
Answering respondent. Okay. Item number 36.
36, your lordship. I'm only
It
praying
will-
for not this
It
week.
will appear tomorrow.
Yes, your lordship. I'm only praying for not this week, your lordship.
Both parties are there. What is your
Mr. Sanjeev Kumar Mal is appearing in this matter, your lordship. Due to his personal reason, I'm asking for this.
Okay, not this week.
Lord, item 37, my lord.
Item 36, not this week.
And 37 for the, I'm for the petitioner, praying for not.
Praying for?
Not this week.
Why? Not this week.
Item.
48,
49.
48, 49 and 50 tomorrow. Pension matter.